Mahasabha, Sri Vijay Maharaj, President General of the Sanatana Dharma Mahasabha, Sri Krishna Rambally, Legal Advisor to the SDMS, and Member of Parliament for Shiborders West, the Honorable Dinesh Rambally, Executive Members and respected pundits of the SDMS, our esteemed panelists, Mr. Anand Biharlal, Queen's Counsel, Mr. Ramesh Lawrence Maharaj, Senior Counsel, Ms. Karen Nunez Teixeira, Attorney at Law, and Mr. Tacklalsingh, Attorney at Law, all specially invited guests, principals, teachers, and students of our SDMS schools, members of the media, page, YouTube, those of you joining us, we extend a warm welcome, ladies and gentlemen. I'm Shriman Mr. Kai, and it's my distinct honor on behalf of the Sanatana Dharma Mahasabha to welcome you to this inaugural seminar entitled The Wide-Ranging Significance of the Final Appellate Court for Trinidad and Tobago here at the headquarters of the SDMS, the Luxury Hills Hindu College, St. Augustine, Trinidad. It is the intention that this event today would provide the opportunity for a clear and most essential examination of the issues surrounding this country's deliberation on whether it should adopt the Caribbean Court of Justice as our final appellate court. The Sanatana Dharma Mahasabha views this theme as not only relevant and topical, but also one that can potentially mark a significant milestone in our nation's history. As a result, our highly qualified and distinguished panelists will today provide academic discourses, well-researched and solid information, as well as expert opinions to help us better understand our topic at hand. So as usual, when commencing all ventures, it's of paramount importance to seek the blessings of Bhagwan. So to lead us in our opening prayer, let's extend a warm welcome to our illustrious Dharmacharya of the Republic of Trinidad and Tobago, His Holiness Pandit Dr. Ramesh Parasram.
So here on to go to right. Yeah.
Ladies and gentlemen, would you please stand for the national anthem of Trinidad and Tobago before we begin praying? Please remain standing, clasp your hands and bow your heads as we pray to Bhagavan Sri Ganesh, remover of impediments and embodiment of wisdom, as we pray to Mata Saraswati, the mother of the universe, in her form as the goddess of wisdom, of learning, as we pray to our teachers, seek their blessings, that we may this day, as we embark upon this important event, have the courage and wisdom to relentlessly pursue the truth. Let us pray. Hari Om Vakkatunga Mahakaya Suryakoti Samaprabha Nirvignam Kuru Me Deva Sarvakaryeshu Sarvada Shuklam Brahma Vicharasara Parama Adyam Jagat Vyapinim Veena Pustakadharinim Abhayadam Jadhyandhakarapaham Haste Sfatikamalikaam Vidadatim Padmasane Samstitam Bande Tam Parameshwari Bhagavati Buddhi Pradasarada Om Akhanda Mandalakaram Vyaptam Yena Characharam Tadpadam Darshitam Yena Tasmai Sri Gurave Namaha Om Shanti 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 Hari Om. God bless you all and thank you very much.
Thank you, Dharmacharya-ji. You may have your seats. Up next, to bring greetings on behalf of the Sanatan Dharma Mahasabha is someone who really needs no introduction. He continues to lead with distinction, ever undaunted, and committed to equality and fairness for all people. We are so very proud of him, our vibrant and hard-working Secretary General of the Sanatan Dharma Mahasabha. Let's welcome to the podium Sri Vijay Maharaj.
Sitaraman, good morning, and a very warm welcome to all of you. It is my pleasure as Acting Secretary General of the Sanatan Dharma Mahasabha to have our special guest presenters, Mr. Anand Ram Biharilal, QC, Mr. Ramesh Lawrence Maharaj, Senior Counsel, Mrs. Karen Nunez Teixeira, Mr. Tacklalsingh, who will speak on a topic entitled The Wide-Ranging Significance of the Final Appellate Court of Trinidad and Tobago. May I say from the outset that this is not a debate. It is not a debate. It is meant to be an exercise in edification, knowledge, meant for the benefit of Trinidad and Tobago. The question before us concerns what happens to us in Trinidad and Tobago if either the Caribbean Court of Appeal or the Judicial Committee of the Privy Council is adopted as our final court of appeal. It is significant because of the word final. There is simply no other option for further redress or appeal after such a court has made its ruling. This is the reason why the Sanatan Dharma Mahasabha has invited such legal luminaries as these persons sitting before you. We consider it a civic duty to educate the public on a matter of such gravity. And I want to thank our presenters for making this event possible. Without further ado, I pass back to our moderator. Thank you.
Thank you, esteemed Secretary General of the Sanatan Dharma Mahasabha, Sri Vijay Maharaj. Well, we're blessed today to have in our midst brilliant students of our SDMS secondary schools. You would agree that they are our future, and we are absolutely delighted to have them join with us today because there is so much to learn with respect to what is being discussed. Some of them will actually be sharing the podium with me in introducing our panelists today. So to actually introduce our first presenter, I'd like to call upon Ms. Dana Dial, who is a lower sixth student of the Lakshmi Girls Hindu College. Let's welcome her.
Good morning. Our first presenter this morning is a young, public-spirited attorney at law. I refer to Mr. Kiel Tacklalsingh, who is no stranger to the Mahasabha, radio, and TV Jagriti. Mr. Tacklalsingh has involved himself in many public interest causes, as well as engaged in public law matters. One of his latest causes was calling accountability on the part of the Attorney General of Trinidad and Tobago. In terms of cases, All of today's daily newspapers report his success in particular judicial review proceedings, which concluded only yesterday. Also, there are news reports of him tackling large conglomerate entities on behalf of ordinary citizens. Over the years, Mr. Tacklalsingh has undertaken public interest matters before the courts, which have led to the development of leading jurisprudence in our legal system. Many times he has engaged in radio and talk show programs with a view to enlighten ordinary persons about their rights. We are all aware of the popular Section 1 legal program which airs on Sunday mornings, where Mr. Tacklalsingh co-hosts with Mr. Stefan Ramkissoon. This program dissects deep-rooted principles of law and their application to modern-day situations. Mr. Tacklalsingh is a founding member of the Sovereign Chambers, where he continues to run his legal practice. Having regard to Mr. Tacklalsingh's track record as a young attorney at law, it is my great pleasure to welcome him to this forum to present his views.
Well, firstly, thank you very much for that rousing introduction. I'm not sure I'm quite deserving of the accolades. Of course, I'd like to acknowledge the Mahasabha, His Holiness, the Dharmacharya, the Secretary General of the Mahasabha, Sri Vijay, President of the Mahasabha, MP, Mr. Rambally, who is always assisting me in both in my professional and public life, fellow guests, an indomitable former Minister of Finance, Ms. Nunez, the Sharer and Attorney at Law, of course, Senior Counsel, my leader often at the bar, Mr. Ramesh Maharaj, and Mr. Anand B. Harilal, QC, you have the pleasure of working with on a matter. Very erudite and gives a lot of good guidance to young lawyers in Trinidad and Tobago. Now, thank you for the opportunity to start discussing this matter. It is always my view that the way that we must tackle problems in a society, in a democratic and free society, is by ensuring that any topic, regardless of how controversial, how uncomfortable it makes us feel, free speech and discussion and debate is the way to deal with it. We do not solve any problems by hiding it in the closet, by failing to confront the problems which confront us, or by sweeping it under the carpet. Free speech is always, in my view, the answer to many of the ills in society. The question of whether we as a people should adopt the Caribbean Court of Justice and move away from the Privy Council is an extremely important one. It is my view that at its core, it's an issue of trust and confidence. Some people put it in different ways. Is it an issue of forging our own independent identity? Is it truly a question of affirming our own sovereignty? Or, as some have said, is it a form of sophisticated forum shopping, where elements of our society aspire to truly become judge, jury, and executioner? We don't know. When you think about it carefully, at its core, any court or any panel of persons that cast judgment on the actions of others must have the trust and confidence of those who they purport to judge, if their judgment is to have any sway at all. At a personal and individual level, we tend to care less about the opinions of those we do not trust. But when those in our inner circle and inner sanctum cast judgment on our actions, we instinctively consider either remedying our actions or relish in our own self-satisfaction. It is by those we trust that we tend to place the greatest weight of their opinion. The decision of our final court of appeal, or the decision of what should constitute our final court of appeal, is therefore firmly rooted in trust and confidence. Without trust and confidence, there can be no legitimacy to the Caribbean Court of Justice, or in fact, to the Privy Council. A NACTA poll in 2019, and I know many of us have our reservations about polls in Trinidad and Tobago, But an ACTA poll in 2019 sought to quantify the levels of trust and confidence reposed in the CCJ. It found that only 17% of those polled in Trinidad and Tobago had supported the move to the CCJ. Now, I'm not quite sure what the questions could have been to the persons participating. The CCJ isn't currently our final court of appeal. Many persons in our society don't have interactions with the CCJ unless you have some treaty dispute, I suppose. And therefore, I couldn't quite understand why the number was so low. If I had to guess, I would say that perhaps it's a result of our own mistrust of institutions. But still, 17% says something. And therefore, if we don't trust the CCJ, you would never have acceptance in our society of acceding to the CCJ as our final court. So how do we build trust? Trust and confidence cannot be bought. It can't be legislated into our collective psyche. It certainly can't come from the Senate or from the House of Representatives. But on the other hand, I don't consider it to be some mythical fire stolen from the gods that only a Promethean hero can bring to us. It is attainable. We can find it. But how do we go about it? And that brings me back to my first point. Free speech, discussing the issues, and allowing society to understand and become familiar with the issues that confront us. And therefore, I would just like to limit my contribution to some of the, I suppose, big ticket items or headlines as to why many people have misconceptions or understandings about acceding to the CCJ or retaining to the Privy Council, and how sometimes I think those arguments are misrepresented. One of them, in my opinion, is cost. There is often a fear amongst people in society that accessing the Privy Council is a prohibitive cost. The first thing I would tell you, and of course despite eminent Queen's Counsel and Senior Counsel here, is that it is not mandatory that you retain a Queen's Counsel or a Senior Counsel to represent you at the Privy Council. Attorneys who represented you in the lower courts, be it the High Court, the Industrial Court, the Court of Appeal, they can also represent you at the Privy Council. And I have noticed in my own viewings of the Privy Council that the Privy Council and the appellate panel of the Privy Council treat all attorneys very respectfully and equally. And therefore, I don't see that necessarily as being a restrictive cost that you have to get a Queen's Counsel, you have to get a Senior Counsel, even the more eminent ones. Replacing the PC with the CCJ, in my view, will not somehow require lawyers to charge reduced fees. It's a third tier of apex court, the CCJ, and would predictably require the same levels of preparation by lawyers and administrative expenses. To put it simply, in my view, the legal cost of the Privy Council would be equivalent to going to the CCJ. The PC, the Privy Council, even before the pandemic, so even pre-pandemic, offered virtual hearings and attendances, and therefore you didn't necessarily have to incur costs in order to travel to London to actually attend the Privy Council. So the PC was actually moving ahead of time. They had virtual hearings, and I remember distinctly one case where the lawyers attended the PC by utilizing the conference room at the Law Association, and they were able to do so, and attend and argue their cases as need be. Another argument that seems to be rearing its head is this issue of colonialism, that the Privy Council is somehow a relic of our colonial past and should be abolished. It should be removed. And this is often, I find, an argument which comes a lot from the administration, from the state, from the government. So is sedition. So is the Public Health Ordinance. So is the Offences Against the People's Act. So is the Customs Act. So is the Income Tax Act. All of these pieces of legislation which found our modern lexicon and cornucopia of laws that we have to follow, our entire, the architecture of our legal system continues to be rooted in many colonial laws or many laws pre-independence. And therefore, I really have a difficulty and let me call it a spade, I think it's quite hypocritical for the state to argue that the PC should be abolished because it's some relic of colonialism that we need to remove. Recently on the Supreme Court website, I read a lecture by Lord Reed. He was speaking on the occasion of International Disputes Week in London. And he noted that London, despite all of the stigmas that are attached with colonialism, continues to be one of the leading forums for legal services. He stated as follows, and this is what he said, noting the stature of London currently. The UK is one of the world's largest centers for legal services, ranked second by revenue only to the US. According to 2 studies published last year, it is the world's leading center for international dispute resolution by litigation, and equally with Singapore by arbitration. What does that mean? That all over the Commonwealth, all over the world, people still insert in their contracts that if we are to go by arbitration, we have to do it in London. We use London arbitrators for dispute resolution. So the world recognizes the certainty of the English common law, and those who have a long and established tradition in deciding the common law in London as having value. We here have the Privy Council that we can access without much process. So therefore, in terms of the argument about abolishing the PC because it's a colonial relic, etc., I find really no merit in that at all. The world is moving towards London, asking for that expertise in arbitration and dispute resolve. Why should we abandon it for that? Quite frankly, I don't accept it. I even find, and again I call a spade, that some of the anti-colonial rhetoric I'm hearing is xenophobic and improper and almost fascist. And I will not abide by that argument, quite frankly. Different values and culture. I heard this one in a debate, that somehow a constitutional court in England has different values and cultures or cultural recognition to the constitutional courts or the constitutional ethos of the Caribbean and Trinidad and Tobago, and therefore we should accede to the CCJ. Again, I don't accept that argument. There is absolutely no truth to it, and in fact, when you look at the cases, the Privy Council on occasion gives deference to local interpretation by judges and our courts on issues of constitutionalism. So therefore I don't see the argument. The only issues of culture and norms and values that we should be concerned about are universal ones, those which are entrenched in all democratic societies. Should we discard Montesquieu's spirit of laws, which set forth the foundations of separation of powers? That was a French intellectual writing in Renaissance France. That forms the basis of all of our separation of powers, concepts and understandings in the Commonwealth and all over the world. It was used in the forging of the American Constitution. Should we get rid of that because it comes from France? No. Should we discard the entire rule of law concept, whereby we should be a society of laws and not men? Some historians place that or locate it in a place called Runnymede in England, where the barons of England were able to extract from the king at that time, I believe it was King John, they were able to extract a treaty, and some of you may recognize the name. It's called the Magna Carta. Judgments all over the world cite it. Magna Carta, when you read judgments on property rights and liberty, they cite sometimes the old quotations from the Magna Carta. That came as a result of a political struggle in England. So should we discard the rule of law as well because it's some different cultures or values? It's not. Constitutionalism and the constitutional values which we should hold dear and which we should strive to protect are not somehow indigenous to Trinidad and Tobago. They are universal. That's why they call it the Universal Declaration of Human Rights. It's throughout all societies, all democratic societies. And therefore, I also find no merit in that argument or discussion. As an example, very recently, the PC was asked to consider the controversial issue of the death penalty in our society. We know that it's controversial in Trinidad. If you do a poll today, you would find a large section of our society saying, yes, hang them. And then some sections of society would say, well, the death penalty really isn't a deterrent, so why do we have it? But then again, why should we pay to keep prisoners? These are the kinds of arguments that you get in Trinidad. So the question still is not fully resolved in Trinidad and Tobago. There's no societal consensus. But in England, it's been abolished for many years. English sensibilities and the right to life are somewhat different to Trinidad and Tobago. And therefore, when the case of the death penalty came to the Privy Council very recently, one would have thought that the Privy Council would have imposed their cultures and values on Trinidad and Tobago. They did not. They did not abolish the Privy Council. They could have. And while, yes, it had to do a lot with something that we call the savings law clause in the Constitution, they didn't try to get around it. They left the issue for Parliament. And therefore, once again, I quite frankly don't understand any argument with respect to cultures and values and why we should abolish the Privy Council. The third issue is sovereignty. We say, and this is how the argument goes to some extent, that because we are a sovereign state, sovereign borders, we no longer have the Queen, we should also abolish the Privy Council. It goes with colonialism, but it's a little more deep-rooted. We became a republic in 1976, and therefore we declared ourselves to be a sovereign democratic state. And because we are a sovereign democratic state, we should handle our judicial affairs in a sovereign manner, in our own borders. But in my view, that is an intellectual betrayal of the highest order. Sovereignty, in my view, has very, very little to do with physical borders. Sovereignty, in my view, is a sovereignty of the kind of the people. Sovereignty, in my view, is when the people of a country can hold its leaders, its government, and the executive to account. And the best way to do that is to ensure that your third-tier court, your final court, as the Secretary General said, there is significance to that. Your final court is a court of repute and a court of independence. In a book I read recently, Edmund S. Morgan, in his work, The Rise of Popular Sovereignty in England and America, describes the requirements of popular sovereignty in this way. What popular sovereignty did require, in the eyes at least of those who thought seriously about it, was a means by which somebody or bodies capable of doing so could speak decisively and authentically for the people so as to contain government, whether monarchical or otherwise. That was a historical perspective on the rise of sovereignty in England, how the parliament was formed and how sovereignty was transferred to the people. So, true concern for our sovereignty is less about keeping everything in Trinidad and Tobago or the Caribbean, and more about ensuring that those who govern us remain accountable and subject to the will of the people of this country, and not the other way around. Modern-day dictatorships around the world have thrived because various regimes have taken control of indigenous judicial systems and judicial officers within their borders. In a book, How Democracy Dies, Stephen Letsky and Daniel Ziblatt studied several dictatorships in modern-day history and observed that elected autocrats, these are two historians, and this is what they say about the modern world, elected autocrats subvert democracy by packing and weaponizing the courts and other neutral agencies. They found that many governments' efforts to subvert democracy are often termed legal in the sense that they are approved by the legislature and accepted by the courts. They may even be portrayed as efforts to improve democracy, making the judiciary more efficient and combating corruption and cleaning up the electoral process. You see, The question is one of something that a term I heard recently, institutional capture. Can independent institutions be captured by your executive? And the answer is yes, on many times. An example from America quite recently, we have all woke up to the news yesterday about Roe versus Wade and about the decision of Roe versus Wade and whether or not a woman has the right to have autonomy over her body and make personal medical decisions for her health. That's a very important question. The question as it's relevant to this debate and how I see it is that Roe versus Wade in America has essentially been a political football. It hasn't really ever, in my view, been determined on constitutional philosophies and principles. It's been determined because of who had control of what judges would sit at the Supreme Court. When Democratic judges or judges appointed by the Democratic government were appointed, you had Roe versus Wade. Recently, you've had political machinations and you've had the packing of the US Supreme Court, whereby the Republican Party has been able to appoint 6 conservative justices. 6 conservative justices. And now you have Roe versus Wade being overturned. And yes, you can argue that there's some merit in it, but in my view, it can't just be coincidence that the shifting of the composition of the court has led to Roe versus Wade being reversed. The same thing has applied in Venezuela, many other states that we know of, where socialist dictatorships have taken control of the country's legislature and established itself as a permanent regime. And that is why, and for that reason, I continue to be of the view, and of course, while we say it's not a debate, I can't express my view. And my view is that we should continue to retain the Privy Council until we have established the necessary trust and confidence in our institutions, in various judicial institutions, in the appointment and promotion of judges, in the speed of justice in Trinidad and Tobago. All of these things have to be dealt with first before we could even start having the conversation about changing the Privy Council to the Caribbean Court of Justice. There is, in my view, a 0% chance of any government of Trinidad and Tobago exerting influence or control over the Privy Council. I can't see it happening. That is not to say that our current judiciary is not independent and robust in its protection of constitutional rights and freedoms. But in my view, the state has exhibited a penchant for capturing and controlling independent institutions in our country. We saw, and I spoke about this, we saw the manipulation of the Police Service Commission, whereby the appointment of a commissioner of police was brought into disrepute. Just recently, we had a decision from the court with Mr. Jawala Rambaran, the central bank governor, where he was fired in breach of his constitutional rights. That is an attack on an independent institution. We had recently an issue of cremation in this country where health officials and public servants were telling us that the cremation, open fire cremation of our dead could spread COVID. As of 2 days ago, you had the government putting off the appointment of the procurement regulator or failing to operationalize the procurement legislation, which is supposed to be another independent institution to assist in our democracy and the way we manage our affairs in Trinidad and Tobago. So what's to say, not this government, maybe not the next, maybe not the previous, but what's to say that a government sometime in the future with more autocratic and dictatorial tendencies would not try to capture the CCJ or judges that have to go to the CCJ. It is my view that more insulation from the executive is better. I prefer more insulation of our apex court from any potential executive. When we make laws and when we take decisions, we don't take it with current circumstances only in mind. We take it in circumstances where we contemplate and imagine what could be the worst. Could we one day become what Orwell spoke about on 1984 England? Or would our democracy flourish sometime in the future, where we become one of the greatest democracies in the world? Our decisions should be guided by not only the current perspective, but what may happen and what is the worst to come. And in my respectful view, at this point in time, I prefer the Privy Council to stay in Trinidad and Tobago for the time being. That is my contribution. Thank you.
Thank you very much, young and vibrant Attorney at Law Kiel Tacklalsingh, for your thought-provoking contributions today. Well, ladies and gentlemen, mass communication, a vision of the late Secretary General, permits us to have with us virtually this morning in Trinidad and Tobago Mr. Anand Biharilal, Queen's Counsel. He's in the UK, so I know it's afternoon in the UK. We extend a special good afternoon to you, sir. And we are grateful to have you with us. Many of you will be able to see him on screen, on stage at this time. And speaking more about mass communications, we acknowledge the hundreds of thousands of viewers who are joining with us via TV Jagriti at this time, also via the Facebook page of the Sanatan Dharma Mahasabha, the Facebook page of Radio and the TV Jagriti, and on YouTube. So we continue along. At this time, to introduce our next presenter, I'd like to invite another student of the Lakshmi Girls Hindu College. She is a student of lower 6, and her name, Miss Nivedita Ramdev. Let's welcome her.
Sitaraman, good morning. Ms. Karen Nunez Teixeira is an attorney at law with special interest in employment and family law. Ms. Nunez Teixeira also holds a postgraduate diploma in international relations from the Institute of International Relations, UE, and an executive MBA from the Arthur Locke Jack School of Business, UE, and the recipient of a Nuffield Fellowship. She is also the author of 3 Commonwealth Caribbean legal texts targeting the law student and practitioner alike. The first on probate law and practice, the second on the status and ethics of the legal profession, and more recently on Commonwealth Caribbean family law. Mrs. Nunez Teixeira has also conducted several business law workshops for companies in Trinidad and Tobago and within the region, and in fact designed the business law module for the then Institute of Business, later the Arthur Locke Jack School of Business, which module she conducted from the inception of the program until her enrollment in the ex-MBA degree program at the school. For almost 20 years, Mrs. Nunez Teixeira was a course director at the Hugh Wooding Law School, and from 2003 to 2007 was appointed to the position of the senior tutor at the Hugh Wooding Law School until she resigned to enter into the political arena. For the period 2007 to mid-2010, Mrs. Nunez Teixeira was a Member of Parliament and Cabinet member appointed to the post of Minister of Finance in the government of Trinidad and Tobago. From 2010 to 2014, Mrs. Teixeira was a senior lecturer at the Faculty of Law, Kiel campus, UE. Currently, her interests are focused on discussing as well as writing articles to the various media on issues which impact on the socio-economic landscape of Trinidad and Tobago, suggesting prescriptions drawn from her experience as an attorney at law, a publisher, lecturer, and former cabinet minister and member of parliament. It is my greatest pleasure to introduce to you Mrs. Karen Nunez Teixeira.
So deep that you probably don't even need the microphone. But first, I must acknowledge the presence of, I'm not familiar with the terminology, so you will forgive me, but I know that based on just his entrance into the auditorium, that His Holiness, Dr. Ramprasad Parasram, is the head of the Sanatan Dharma Mahasabha. And I'm going to say DSDMS, so I don't get myself into too much trouble. And of course, the Secretary General, Sri Vijay Maharaj, and all the members of the SDMS Dinesh Rambally, who I think had much to do with my presence here this morning. Unfortunately for him, or fortunately, he has to decide, a former student of mine. So I get straight to the point. And I think that we agree this was not a debate, but the passion with which my esteemed colleague made his presentation makes one think maybe takes the line of differing of opinion on a matter that is so important and so critical, not only to Trinidad and Tobago, because you must remember that the Caribbean Court of Justice is not the final appellate court just for Trinidad. It is the final appellate court for Commonwealth Caribbean jurisdictions, those that have already joined, which would be Barbados, Dominica, Guyana, Belize, and Barbados. So those are the court. They have already have the CCJ as their final court of appeal. So the question is whether Trinidad and Tobago should join and relinquish our ties with the Privy Council as our final appellate court. And I believe that the point was well made by Mr. Tacklalsingh that it is the final court. So there's no going after that. You come to the end of the road. So I propose to deal with this topic partly, as he has done, with the implications of having Trinidad and Tobago accepting, as other jurisdictions have already, the CCJ as the final court of appeal. And we know that the role of the judiciary in any democracy, and our own is, and he gave us the history, for which I am very thankful, the Westminster model of democracy, that the court, in a sense, is our protector and our gatekeeper of the rule of law. So that we can never underestimate the importance of the final appellate court, be it the CCJ or, as it is at the present, the Privy Council. Right. So I propose to state my position frontally. I'm not going to end at the end and say what my position is. I'm going to say it at the beginning. I am one of those who holds the views that the time has come to take that leap of faith and to make the CCJ our final appellate court. Indeed, Sir Hugh Wooding in 1974 spoke of the urgency to be independent, to replace the monarchy with a republic, to control our economy, to determine our destiny, and ensure decisions affecting the people of Trinidad and Tobago are made as far as possible by the people of Trinidad and Tobago. Indeed, Section 1 of our Constitution asserts that the Republic of Trinidad and Tobago shall be a sovereign democratic state. And I heard what the previous speaker said, and what he said has a lot of value in terms of the passion, the feeling of that many people have. And he said that they did a survey, which he did say that you're not quite sure how the survey was conducted, what were the questions asked, but it's definitely the question of abandoning, so to speak, the the Privy Council, and becoming part of the Caribbean Court of Justice is a matter of grave concern to Trinidad and Tobago. And I would say that his argument that sovereignty can't just be the answer. The feeling of passion, the feeling of emotion, the feeling that we belong to, that we want to be truly independent in that sense. I don't think that is sufficiently persuasive for one to say that is a good enough reason to discontinue our relationship, having the Privy Council as a final appellate court. But I will say this, and it comes to the issue of access to justice. I noted in his contribution, Mr. Tacklalsingh said, and he made the point, that the legal fees, meaning the fees of counsel, are no different whether the matter is heard in 134 Henry Street, Port of Spain, or whether it's heard all the way in London. It makes no difference. And he is correct on that. It's a matter between counsel and his client. And that is true whether it's London, or whether it's Trinidad, or whether it's Barbados, wherever. But what does make a difference, and he knows this because, unfortunately, one of your guest speakers, just by coincidence, represents one of the parties on the other side, in which I have, for the last 4 years, trying to have my matter heard before the Privy Council. Yes, I am before the Privy Council. So I'm not one who's speaking about it in a theoretical construct. I'm speaking about it. It's just a matter of coincidence, because I don't think that it was known when I was invited to participate. So supposedly, all things being equal, and there's no further request for delays, it will happen on next 3 weeks. We hope so. So what is the problem with the access to justice? Well, fundamental to the establishment and maintenance of the rule of law is the right to exercise your legal rights. The financial impact of access to the courtroom has a disproportionate impact on the poor and the more vulnerable. Lord Hoffman, in the case of Tucson versus the Attorney General, observed on the issue of access to justice, you should be able to get to the courtroom and be heard. As a key tenet to the rule of law and procedural fairness, you must be able to get to the courtroom. In other words, one must demand to have access to justice. The undeniable fact is that for many a litigant, other than government entities, private companies, and perhaps persons as stubborn as I am, access to the final appellate court is not located on 134 Henry Street, Port of Spain, but in London, England, for whom the financial cost to get to the court, get to the courtroom, not your lawyer's fees, get to the courtroom is financially prohibitive. The financial costs are substantial, and that does not include the legal fees of your attorney. In fact, your attorney might start feeling sorry for you and say, well, I might waive my fees because I know what it's going to cost you to get to London. And what does it mean to get to London? To get to London, you have to pay the airfare of the attorney, and usually he will go with a junior, his hotel accommodation, his per diem allowance, and very importantly, the solicitor's firm in the United Kingdom who acts as agent for your local firm. When you add up those costs, and they're all in pounds sterling, in one of the most expensive cities in the world, I can assure you, I'm not speaking I'm speaking from personal knowledge. When you add up those costs, it may end up being the cost, not in my case, perhaps that is why I have persisted, but in many a case, those costs alone may be the damages that you are seeking. And what made me look before, just as the invitation was a little late, no problem, I have difficulty with that. But I then decided, let me go on the Privy Council website and see the matters coming from Trinidad and Tobago. And nearly every single one involved the government. Nearly every single one involved private enterprise. And you might ask yourself, why is that? You know why that is? This is the reality. This is the reality. When a litigant decides to appeal a decision, it means he lost. He lost. He may not have lost at the High Court, but he certainly lost at the Court of Appeal. He lost at the Court of Appeal. That's why he is the appellant. Now, when he appeals, do you think the respondent who won and who has been paying legal costs all along, which will be legal fees, which is regardless of jurisdiction, you'll have to pay it anyhow. Do you think they have the choice of saying, I cannot afford to defend this matter? If you take that decision, you have just lost your case, because you will get judgment in default. So you are forced. That is why I noted how many people, when we talk about access to justice, is it really access to justice? When I am confident that there are many, many, many people who have strong cases, who cannot afford to go to the Privy Council unless it's pro bono, but not everybody's going to do pro bono work. Cannot afford to go to the Privy Council. And I'm not talking the lawyer's fees, I'm talking about those costs which are substantial. So we cannot underestimate the importance of that. And I do not know if it's a coincidence I said that when I did this cursory review, then nearly every case involved the government or a state enterprise or a private company. Very few were individuals. So as Sir James Matthew, an Irish judge of the Victorian era, observed, and it's quite true for us today, he said, in England, justice is open to all, just like the writs. And for those of you who don't know the writs, you've got to have lots and lots of money to get in the writs, but you could go, as long as you could pay. So the whole concept of access to justice, which is fundamental to the rule of law, having a court in London does not assist many people, especially those who do not have the very deep pockets or are not government institutions, and who know, and very well know, that you are not able to defend yourself because you simply do not have the means, the financial means to do so. So I move on to another point, and I put it as a question. Statutory laws, are they subject to British values and beliefs? And Mr. You have to forgive me if I take people's names and make a terrible mishmash of it. Vijay is very easy for me to say. Kiel, but I want to be respectful. Kyle is very easy for me to say, so I hope he doesn't mind me saying Kyle. And I mean no disrespect at all, not from my family and not from the family from which I come. So the question is, the concerns that British values and social cultural beliefs, however valid they are to England, have the capacity to effectively override or even nullify our statute laws by virtue of decisions of the Privy Council, no doubt should for sovereign states as Trinidad and Tobago be a matter of grave disquiet. The case has certainly caused judicial anxiety, and we all know about it, I think, was the 1995 Jamaican murder case of Pratt and Morgan. I think all of us have heard it at some point in time, Pratt and Morgan, in which the Privy Council held that while the Jamaican legislation, which is the highest law after your statute is your constitution, unless you have a Magna Carta, while the legislation which provided that the sentence of murder was a death penalty, that in effect a delay of 5 or more years amounted to cruel and unusual punishment, and as such an infringement of their constitutional rights. And therefore the decision was that their death penalty was commuted to life in prison. Now what happened as a result? This vision meant that all Commonwealth Caribbean jurisdictions, including Trinidad and Tobago, were compelled to reduce the death penalty to life imprisonment, because if they're going back to the same law lords, they were going to come to the same decision. All right? So that basically is the reason. Now, I am not advocating one way or the other on the death penalty. I am not. I do have a view on it. I'm not expressing a view on it. But with this case, and more recently the Budram case and the Chandler cases, they have illustrated, as eloquently expressed by the former Chief Justice de la Bastide, the following impact of the decision in Pratt and Morgan. He had this to say. He wrote an article in 1995, soon after the Pratt and Morgan decision was handed down. He had this to say: that the ruling by the Privy Council, at that time he was the Chief Justice, he had this to say, that the ruling by the Privy Council came perilously close to that which would normally be achieved by legislation. That is a partial abolition of the death penalty. He argued further on in his article that he had written on the topic, why 5 years? Why not 7 years? After all, many preliminary inquiries in our jurisdiction, whether right or wrong, take longer than 5 years. So what's the magic in 5 years? Why 5 years? So the point that was being made, and I hope is being made here, is that their unfamiliarity with the socio-economic and political and cultural realities of a former colony perhaps led them to decide that 5 years was enough. So now that magic number, 5 years, once you are awaiting the execution, which you have many ways of delaying it, after 5 years, the sentence is automatically commuted to life in prison. And it is of no coincidence that England, their philosophy and their belief is anti-death penalty. They are passionately against the death penalty. And in my respectful view, following Pratt and Morgan, following Boudram, which was just recently heard, and the Chandler case was recently heard, which dealt with, we don't want to go into too much legalese. I'm not going to go into too much legalese about the effect of Section 6 and the saving clause and how to interpret it and so on. But the effect of these decisions coming from the United Kingdom at every turn have had the effect of frustrating whether you agree with it or not. That is not the point. I am not agreeing or disagreeing with whether we should have the death penalty. What I am saying is you are having persons effectively imposing, because that's what it is, imposing their values, their philosophies, and their views on a former Carib colony which has a statute that says in the Offences Against Persons Act that the penalty for murder shall be death, effectively neutralizing, effectively making it of no substance, mainly because of their ability to make decisions, judicial decisions that impact on our right, whether right or wrong. I am not going with the right or wrong. Our right to execute or to remove the death penalty as it stands. They are imposing that. And we've had my honorable colleague, Kyle, hope he doesn't mind me calling him Kyle, but he also made mention of the public health regulations. Yes, where they said, went to UK, and the United Kingdom said, no, I'm not saying we don't have to take some responsibility, because we could go to Parliament, but we could never agree in Parliament. And some of this legislation needs special majority, so that's another story. But the reality was, I believe what motivated the application to challenge the public health regulations made under a public health ordinance when we were a colony was that the fact that the Hindus, in accordance with their religious beliefs, could not have open cremations or limited the number of persons. And so I think what the idea was that those regulations were unconstitutional. But guess what England said? You know what England told us? England told us, no, they're constitutional. Because your Constitution Section 4 is not an absolute right, it's a proportionate right. So they're saying that you cannot practice. How many Hindus are there in United Kingdom? If they had an understanding of the cultural and the social and the religious significance to the Hindu community, I wonder if that matter had been heard by the CCJ, if we would have had a different outcome. So that goes to imposing the British values on us by way of legislation. My third and final point on that is, which is what Kyle spent most of his time on, and that was a very good point. I want to say one thing on that issue with British values. I remember we said that I taught family law, and I brought my family law book only because this morning I had this little eureka moment, and I remembered the case. And the reason I brought it up is because it was a case years before we had legislation, the Cohabitational Relationship Act. In fact, I think it is that case that led to the legislation. And Justice Sharma, he was a Justice of Appeal at the time, he heard the case. And it was Harinarai versus Aziz. The bottom line was that the children of the man died, and he had children from, I think that even if he wasn't married to the deceased wife, she was not his wife-in-law as we understand it. The Status of Children Act meant that they were entitled to the property. And we had no common law laws, we had nothing to protect her, really, and they threw out the house. And Justice Sharma had this to say about England and our values. He said, when he talked about the common, he talked about our values and our cultural norms. He said, in this jurisdiction, meaning Trinidad, when there is a common law marriage, there's little or no difference in substance between it and a lawful marriage. I would hate to think that in our jurisdiction, a common intention cannot be inferred merely because the common law wife who has spent her earnings on food, books, and clothing for her children and on other household expenses is not able to show that she did this to enable the husband to pay off the mortgage. I am prepared to hold that in our jurisdiction, the living together in such circumstances, that this amounts to prima facie evidence of a common intention and that she should have a beneficial interest in the property. This is my judgment. To come to any other decision would be repugnant to any decent person's sense of marriage. Or he said, this in my judgment will be a common intention inferred by reason of the unique position of the common law marriage in our society. Okay? So we understand that they don't understand our traditions as well as they should. And that is an argument. But I'll come to the final point, which probably Kyle might feel a little comforted by, and it's a very good point. The lack of trust and confidence. That is a real, we can't get around it. It is a real and tangible concern. Jamada, Justice A, at that time he was a Justice of Appeal. Now he's a member of the Caribbean Court of Justice, ironically. Clearly understood the reluctance, the fear of replacing the Privy Council with the Caribbean Court of Justice, staffed by judges from the region who would now be entrusted with the duty and responsibility to render justice that was fair, unbiased, and free from the taint of political or other influences, in a region relatively small in number. In July 2019, Justice Jamada acknowledged that the fare was not unreasonable, as we are all aware of judgments delivered by the Court of Appeal which raised the issue of impartiality and that the scales of justice not being blind. So I don't propose to pursue that, safe to say that the smaller the pool of judges and the smaller the size of the jurisdiction, those fares are not unjustified. But I am of the opinion that in the very same manner, when I was to be among them, when we were the early graduates of our regional legal institution, were disdained and disparaged and called locally assembled. Used to call us locally assembled lawyers. And not quite up to the caliber of the intellectually or otherwise superior graduates who had got their qualifications in England. We too will arrive at that watershed moment, that cases such as recently concluded case in Guyana, which jurisdiction shares so much in common with us, culturally, socially, ethnically, religiously, should give us a measure, that decision should give us a measure of confidence that we can put aside and we can put our trust and confidence in our indigenous institutions and say indeed that we are a sovereign state. Final thoughts, and this is how I end. It seems that the major fear of relinquishing our ties and the Privy Councils of Final Appellate Court, as has Barbados, Belize, Dominica, Guyana, is born out of that distrust and lack of confidence, not only in the quality of the Caribbean judges, but more in their capacity to set aside personal, emotional, even political consideration and render justice impartially. So what steps were taken? Because we have to know steps were taken. And among those steps are that we know that he who pays the piper plays the tune. So what they did to ensure that political or governmental pressure of a financial nature, could minimize the role it played in the decisions, they established a trust fund with a starting sum of $100 million US. And it was invested by a team of investors, all highly qualified and from various jurisdictions within the Commonwealth Caribbean, so that the expenses and remuneration of the judges are not subject to political interference. So too the appointment of the 7 judges. 2 are from Trinidad, the president from St. Vincent, 1 from Barbados, and the final 2 from Belize and Jamaica. It is also my understanding that when a matter is from a jurisdiction from which a judge is a citizen, he or she is not included in the judicial panel. Is there more that has to be done to create the judicial insularity and independence of the judiciary? I'm sure there is. But are we to hold on for time immemorial to our resistance to a court that was once quoted as saying, certainly one of its members, that the time has come and indeed gone when we need to relinquish our ties to the Caribbean Court, the Privy Council, and finally relinquish one of the final remnants of our colonial status and take a leap of faith. So that is my contribution. Kyle, you're clapping it. Thank you for listening to me, and I hope at least it was educational, if nothing else. Thank you.
Thank you so very much, Ms. Karen Nunez Teixeira, for your clear and profound presentation. We are so appreciative of your time and for sharing with us this morning. Privy Council versus Caribbean Court of Justice as the final appellate court, implications, consequences, the impact on justice, the gravity of this issue, friends, cannot be underestimated. And this is why the Sanatan Dharma Mahasabha views these discussions as most critical to bringing forth enlightenment, understanding, and awareness to all citizens of Trinidad and Tobago and those around the world. Today's panel comprises a mixture of distinguished and qualified personnel with experience both locally and in the United Kingdom. Some of these practitioners have at varying times worn the caps of legislators, litigators, lawyers, locally and foreign assembled, public spokespersons, and lecturers who all help us shape the jurisprudence of our country. We again are extremely delighted to have them with us. Our next presenter will be joining us virtually from the United Kingdom. He's live with us, but his presentation has been done via a recorded video just to ensure the smooth flow and, of course, no unpleasant surprises with our internet and technology. So to introduce him, I'd like to invite a lower sixth student of the Lakshmi Girls Hindu College, Miss Renita Bharat-Singh. She will be telling us all about our next presenter this morning. And those of you who are here with us in person, you can focus your attention on screen, on stage, and listen to the presentation. Miss Bharat-Singh.
Sitaram, good morning. Anand Biharilal QC is a British Trinidadian barrister and attorney at law. He was called to the bar in England and Wales in 1997 and Trinidad and Tobago in 2001. He holds the LLB Honours and LLM degrees, and is a past student of St. Benedict's College, La Romaine. He took Silk in 2018 at a relatively young age of 42 in his 17th year of full-time practice. He is a member of the leading barristers' chamber, 2 Bedford Row in London, and has been cited in the leading directories chambers and Partners and Legal 500 as one of the top lawyers in practice today. He practices before the courts in England and Wales, Trinidad and Tobago, and has advised and appeared in appeals to the Privy Council for almost 20 years in both civil and criminal cases. Mr. Biharilal QC has appeared many times before the Privy Council, arguing appeals from Trinidad and Tobago. There are numerous written judgments from the Privy Council, where the law lords of the Privy Council have seen it appropriate to praise Mr. Biharilal and to codify the commendations of his superior advocacy. He has worked with many Caribbean lawyers, including Sir Fenton Ramsahoy, SC, Ms. Ramesh Maharaj, SC, and Mr. Dinesh Rambally. His father, the late Renal Biharilal, was a prominent San Fernando attorney who was active in the local Hindu communities, and his mother, the late Sham Ramasri Biharilal, was a nurse from San Francisco. Mr. Biharilal is always eager in teaching and counseling of young lawyers and giving back to local communities. Today, he has seen it fit to participate in this very important discussion. Anand Biharilal QC joins us today via a video link from London as one of our esteemed panel speakers.
Namaste and good morning.
What is the Privy Council?
What is the Privy Council? The Privy Council is the final appellate court for Trinidad and Tobago, which deals with points of law.
Why is it the final?
Why is it the final appellate court for Trinidad and Tobago?
This is because the sovereign parliament of Trinidad and Tobago decided to enshrine in our highest law, that is the Constitution, that the Privy Council should remain after independence. In this context, it is important to remember that the Parliament has made the decision twice to retain the Privy Council as its final court. The first time was in 1962 when Trinidad and Tobago became independent, and the second time was in 1976 when we became a republic. Parliament did create some exceptions. For example, election petitions cannot be appealed to the Privy Council. Criminal cases can only be appealed if the Privy Council gives permission. And there are financial thresholds for civil cases before an appeal can be brought. These again were deliberate decisions by the Trinidad and Tobago Parliament. Caribbean judges can sit in the Privy Council. Indeed, our very own Sir Hugh Wooding sat as a judge in the Privy Council, and more recently Sir Edward Zaka from Jamaica also did. What is the Caribbean Court of Justice? The Caribbean Court of Justice was set up to replace the Privy Council in the Commonwealth Caribbean in 2005. If Trinidad and Tobago decides to accede to its jurisdiction, the Caribbean Court of Justice will inherit all of the appellate functions presently vested in the Privy Council. In addition, the Caribbean Court of Justice has an original jurisdiction to interpret and apply the revised Treaty of Chaguaramas, which established the Caribbean Community. British judges cannot sit at the Caribbean Court of Justice. Caribbean Court of Justice judges are appointed full-time, and the only English judge was Justice David Hayton, who has now retired. Reasons for joining the Caribbean Court of Justice. 3 main reasons have been submitted. A. The high cost involving appeals to the Privy Council. B. Completing the independence of the Caribbean. And C. Judges in the Privy Council are far removed from the culture of the Caribbean region. As to cost, this is largely determined by lawyers who are instructed. Some lawyers will charge quite high fees, others will charge low fees. It all depends on the nature of the case and what is at stake. Indeed, the state of Trinidad and Tobago, that is the government, frequently instructs English barristers to represent the state, even though it has quite distinguished senior counsel from Trinidad and Tobago. If cost was a genuine issue, surely instructing local lawyers instead of English-based lawyers who would work for lower fees in TT dollars would make more sense. If one assumes the state is seeking value for money, then it means that the level of fees is relevant, and it must follow that they retain English counsel because they are cheaper and well able to do the job. As to completing independence, this is to confuse and conflate independence of the state with an independent judiciary, the latter which must always be independent of both the state and the citizen, as it must often pass judgment on both. There are many people who like to beat the colonial drum as an argument on abolishing the Privy Council, but this ignores the fact that an independent Trinidad and Tobago made the conscious decision to keep the Privy Council when it could have removed it, both on independence and later as a republic. Trinidad and Tobago's Parliament decides what laws it wants to keep from the pre-independence era, what laws it wants to change, and what legal system it wishes to have. And in exercising those powers, it has deliberately chosen to keep the Privy Council as it is entitled to do as an independent and free state. As Dr. Eric Williams explained after Trinidad and Tobago became a republic, the Privy Council is not inconsistent with independence of a country. They are two different things. In fact, the Privy Council, being far removed from the local politics of the Caribbean, means that it is often best placed to determine important issues of law, particularly public law, without being concerned about local pressures about how the case should be decided. In that way, it possesses an ultimate independence. A balance is struck because the Privy Council gives careful consideration and due deference to views expressed by local judges, especially if cultural perspective is relevant and important in an individual case. Arguably, the Caribbean Court of Justice, being a regional court, has less reason to do that. As to culture specifically, cultural norms, like public opinion, can change week to week, month to month, and year to year. The law is not amenable to such change simply because cultural norms may change. Culture is important in understanding a society, but the culture of a society rarely dictates what the law should be. And if culture is decisive, the question then arises, where you have a country like Trinidad and Tobago with mixed cultures, how will that be balanced? Does it mean that the dominant culture in a society, which perhaps has religious connotations, should be elevated over another? And where does the Hindu culture fit into that? This does not make for certainty in the law. The law demands certainty so that people can look to the decisions made by the final court as setting out decisively what can and cannot be done, whatever one's culture, and irrespective of how public opinion may change in the future. And if culture is a decisive feature for Trinidad and Tobago, then arguably it would make more sense for having a final Supreme Court of Trinidad and Tobago sitting above the Court of Appeal, which has exclusively Trinidad and Tobago judges. I am not aware that the Caribbean Court of Justice has yet had to express any views in relation to issues concerning the Hindu community in any great detail. Hindus are, of course, a minority in the Caribbean, but in Trinidad and Tobago they make up a significant and prominent part of the population, and there are serving judges in Trinidad and Tobago who are Hindu by faith. Perhaps the Caribbean Court of Justice may have to confront issues in relation to the Hindu faith in appeals from Guyana. For my part, I would certainly be interested to see how the Caribbean Court of Justice might approach such issues. It would certainly give them an opportunity to demonstrate if and how they appreciate the differences in the cultures of the Caribbean. Irrespective of that, it would certainly be a mistake to assume that every Caribbean state has the same culture. But it comes back to the same issue that culture is not and cannot be a decisive factor in Trinidad and Tobago signing up to the Caribbean Court of Justice. Reasons for keeping the Privy Council. For Trinidad and Tobago at this time, the main reason for keeping the Privy Council is that it is far removed from the local politics and the dysfunctional nature of public institutions generally in Trinidad and Tobago, whether it be local government, WASA or state-owned companies. There is a public perception that is widely shared in Trinidad and Tobago that people cannot get justice before its local public institutions, and so they gain a degree of confidence in having the Privy Council which is unaffected by that perception. To put it simply, people feel that if it goes wrong in the local courts, it can be put right in the Privy Council, and if they do not get the result they want in the Privy Council, they still feel that they have been fairly heard. The concept of a local Caribbean final appellate court is not new and has been discussed prominently since the 1970s. Views have varied since that time, some of which supported the creation of court and others that didn't, the uppermost concern being the risk of political influence or pressure if the Privy Council was removed. One particular person bears mention, Sir Roy Marshall, then Vice-Chancellor of the University of the West Indies, who said, "The assertion that the continuation of appeals to the Privy Council was a negation of independence, though politically persuasive, had no logical or legal validity." This was because, in his view, no Caribbean country had a choice whether to sever ties with the Privy Council until it became independent. Those states only acquired a choice by which they could have exercised sovereignty after the attainment of independence. Sir Roy doubted whether a proper case had been made out for a Caribbean court to replace the Privy Council. This, in his opinion, was because the proponents of the Caribbean court did not see its establishment as an end in itself, but rather as another institution which would lead to closer political integration. Later, in 1974, the Wooding Commission, as it became known, noted that opinions against the establishment of a Caribbean court to replace the Privy Council were the result of a lack of confidence. And a memorandum which was submitted by lawyers, which is contained in the Minority Report, cautioned against the introduction of the Caribbean Final Court on the grounds, among other things, that to stand aloof from the Privy Council at this stage in favour of a local jurisprudence is, in our view, an attempt to rationalise in political desire to remove ourselves from what was our colonial past. What can be seen when you look at those past comments is there is a consistent theme, a concern about political motivations, which indirectly pointed to concerns about political influence, if not direct political pressure, and this remains a concern today. Following the decision yesterday by the United States Supreme Court, striking down the 50-year-old case of Roe v. Wade, you can see that now that abortion rights and women's constitutional right to choose will now be restricted, the decision has been informed by political appointments to that country's final court. And so political appointments and political influence can have huge ramifications for people's rights, especially if the court is heavily weighted in favour of one political view or ideology, which can have the effect of dividing a people. Direct concern has been expressed as to how the Caribbean Court of Justice judges will be appointed in the future, from a judicial pool who have been appointed locally, where there is a concern, at least in some appointments, that the appointments have been politically influenced. Whether that is a fair concern is a separate matter, but it is certainly one that the public has expressed. As to political concerns, an unfortunate situation arose in 2009 that brought into sharp focus the risk of local politics affecting the perceptions of the Caribbean Court of Justice. At that time, a sitting Caribbean Court of Justice judge, who was not originally from the Caribbean, gave an interview in which comments were made about matters which were inherently political, specifically concerning Trinidad and Tobago. Amongst the things that were said included a commentary that the then Prime Minister of Trinidad and Tobago had too much power, so there was no need for an executive presidency. There was also criticism of the Prime Minister's power to veto appointments of the Director of Public Prosecutions, Commissioner of Police, Solicitor General, and the Chief Parliamentary Draftsman, all of which are key and important public positions that should serve all peoples. Comments were also made as to the power of veto by the Prime Minister of who can run for an election, even naming a distinguished politician. Comment was also made that while a certain person remained leader of the opposition, this had the direct effect on the political climate and accession to the Caribbean Court of Justice. Whether or not there may have been any accuracy in some or possibly all of the comments that were made, the fact of the matter is that a judge should not have made them. More importantly, it demonstrated an acute sensitivity to the politics of the day, which is exactly why historically there have been concerns that a local judiciary can be affected, even if only inadvertently, by local political influence, if not pressure. Whatever the politics of the day, it should never have an influence on how the court should gauge or decide particular issues. It should only ever comment on political matters if that is relevant to the case before it. The role of the court is to be above and beyond politics and to look at the law and the purpose of the law and the development of the law in a progressive way for the benefit of the people that the law is supposed to serve. If political personalities are viewed negatively by judges, then what will happen when cases which have political implications go before them? Depending on the political party or personality, does it mean that he or she will be treated differently than his or her rival? These are uncomfortable questions, and the answers are equally uncomfortable at this point in time. This one event in 2009 created tremendous alarm, and to a lesser extent since. Whether and to what extent the views expressed were confined to one person or shared by others, we will never know. But it was enough to justify the concern that locally based judges can be influenced by the politics of the day. Another key factor is economic, of which the Bahamas is a good example, where a former president of the Bahamas Bar Association about 10 years ago was referred to as saying that abandoning the Privy Council was treading on very dangerous ground. The learned president of the Bahamas Bar Association further stated on a popular radio program, when you are dealing with financial matters and the economic impact of it, litigants who come to our courts need that reassurance that there is some place of last resort that is independent and seen to be independent. Litigants who come before us with multi-million-dollar cases and they see us as a great financial centre, they need assurance that the Privy Council is there. Similarly, the Cayman Islands and the British Virgin Islands, which are major financial institutions and jurisdictions in the Caribbean, show no real sign of being interested in abandoning the Privy Council. In the Cayman Islands, there is a very strong desire to maintain a system very heavily based and very close to the English legal system, and this shows in the very strong presence of both English judges and English lawyers who practice regularly in that jurisdiction, both in civil and criminal cases. Aside from politics, there are other examples that illustrate that the Privy Council should perhaps be kept at this point in time. One of them, and I know he's going to be speaking later in this session, is the case of Ramesh Maharaj versus the Attorney General, where then a young barrister was jailed for contempt of court. He appealed to the Court of Appeal, but he ended up having to serve 7 days in prison. He then appealed to the Privy Council, and the Privy Council firstly quashed his conviction for contempt of court, which was right, because the young barrister had only been doing his job in court when representing a client. Secondly, a constitutional claim had to be brought, which was rejected in the courts in Trinidad, but succeeded in the Privy Council, where the young barrister, Ramesh Maharaj, secured a declaration that his fundamental rights had been breached and that he was entitled to compensation. Many people may ask, well, that was 1979. What relevance does it have today? The short answer is that that case from 1979 set a precedent in demonstrating just how unfair the local legal system can be, even making allowance for local practice, procedure and culture. And had the Privy Council not existed to vindicate Ramesh Maharaj's rights, Trinidad and Tobago would never have benefited from the tremendous work that he subsequently did and continues to do some 50 years later. The decision itself remains relevant, not least in a case in which I appeared last year called Duncan and Jochen. In that case, the High Court and Court of Appeal rejected a constitutional claim in relation to two people who were forced to serve 3 years extra in prison than they should have due to an error by the Court of Appeal. The Solicitor General's office agreed that the error had been made, but they declined to agree that the appellants should be released on a constitutional motion, and as I say, the local courts upheld that position. The Privy Council, however, applying the decision of Maharaj versus the Attorney General from 1979, made clear that those principles still hold good, and that the constitutional motion procedure was exactly the right procedure to bring the case before the courts to secure the release of those individuals. Bearing in mind that Caribbean Court of Justice judges are drawn in part from Trinidad and Tobago, it is easy to see how they might have drawn a different conclusion to the Privy Council in upholding those rights. Another troubling appeal was Batordier versus the Attorney General in 2021, where the arrest of a young soldier for kidnapping was upheld by the local courts, even though there was no evidence to support it. The Privy Council reviewed that on a point of law and agreed that the conclusions of the courts below were not justified and that he ought not to have been arrested and was entitled to compensation. When one considers that both of these cases concern the powers of the state to arrest and detain citizens of Trinidad and Tobago, one would expect that the local courts would be far more sensitized to the abuse of power. On the other hand, it may very well be that because of the level of criminality in Trinidad and Tobago, that local judges have their view influenced by that as to how they determine certain cases. Again, this brings into focus judges appointed to the Caribbean Court of Justice, and that they will be drawn from this pool of local judges. And so it is perhaps inevitable that a local judge's view will have a direct bearing on how they deal with these cases in the future, which is likely to mean that liberty of the subject in the Caribbean could be dealt with more restrictively in the future. Many people in Trinidad and Tobago share the concern about how a local final appellate court might roll back the protection of rights guaranteed in Trinidad and Tobago's constitution. Whether this view is justified is a matter of debate. So what about the future of the Caribbean Court of Justice? Well, any Caribbean state, but of course I focus on Trinidad and Tobago as a citizen of Trinidad and Tobago, if it is serious about joining the Caribbean Court of Justice, it needs to do more to improve public confidence in local public institutions. And this means, at this point in time, a major drive to ensure that people from different communities in Trinidad and Tobago are treated equally. This is not simply confined to racial or religious equality, but includes mainly class equality to ensure that all people, whatever their economic status, are treated with equal respect under the law. When it comes to criminal justice, it cannot be right that a young person age 18 is arrested for a crime and remanded in custody and will remain there until he turns age 30 before he is tried. No civilized society can tolerate that, and the signing up to the Caribbean Court of Justice cannot solve that problem if the government refuses to assign resources to the local justice system. In addition, and equally important, is the manner and procedure by which judges are appointed in Trinidad and Tobago. It should be completely transparent, and the fear of political alignment or influence or improper influence of any kind should not be a criticism that could be raised. That is because if the appointment system of the local judiciary is flawed and perceived as unfair, this will perhaps have the greatest knock-on effect in a lack of confidence in the Caribbean Court of Justice, because, as I've said, Caribbean Court of Justice judges of the future will be appointed almost exclusively from the Caribbean islands. But if the local appointment system is politically aligned or perceived to be so, then it will do nothing to support the confidence in the local judiciary or the Caribbean Court of Justice, because people will know that the same judges appointed in the Caribbean, of whom there may be concerns, will soon be sitting in the Caribbean Court of Justice. Again, this is something to consider, and there are differing views about it. But the point is this: unless and until Trinidad and Tobago deals with these problems in the local justice system, which affects people in Trinidad and Tobago more directly, it is doubtful the public will ever give majority support to the Caribbean Court of Justice. And indeed, in other Caribbean islands, that view may be shared, and almost certainly has been shared in those islands that have considered and rejected the Caribbean Court of Justice in recent years. Antigua, Barbuda, and Grenada are good examples. Grenada has, of course, rejected the Caribbean Court of Justice twice following referendums. The local judiciary can play a positive part too, by itself adhering to the stated values of the Caribbean Court of Justice. A. Integrity. Be honest, do right, stand firm. B. Courtesy and consideration. Demonstrate care and respect for all. C. Excellence. Demonstrate the highest quality of service and performance. D. Industry. Be diligent, go above and beyond. The second of these, courtesy and consideration, is the most important today. In any case, whether it is a civil case or a criminal case, one party must succeed and the other party will not succeed. That is the nature of the adversarial system, and most people understand that. However, it is common knowledge, particularly among the legal profession, that where a judge acts with courtesy and consideration and demonstrates care and respect for all, it is easier for the litigant who may lose to accept the decision. That litigant feels that he has had a fair trial or a fair appeal before the local courts. It may mean that they do not wish to appeal to the Privy Council or to the Caribbean Court of Justice for those countries who have it as their final court. But where the judge or judges are hostile and angry towards the litigant, refuses to listen to the litigant, or indeed the lawyers, if that litigant loses, she or he will always feel that they received less than justice before the local court. And it is these litigants in the main who consider appealing the decision, whether to the Court of Appeal or to the Privy Council. Many appeals will not be brought if the judge is first and foremost courteous and considerate. But coming back to the primary question of resources, if the government is receptive to the problems that the local justice system faces, and this affects any party that is either in government or aspires to government, the people of Trinidad and Tobago require now a major investment in the criminal justice system, increasing the number of prosecution lawyers, increasing the number of defense lawyers, increasing the number of judges and magistrates to try these cases. We need a major investment in increasing the number of courts to at least twice the number they presently. Diversity in the judiciary and increase the judicial pool, eventually, for judges who might go to the Caribbean Court of Justice. Criminal cases pending for more than a decade should become a thing of the past. It does not matter which party is in government that makes these changes, because whoever does it will win public support. What is important is that the government takes these steps. If this happens, it will go a long way in improving confidence in the public, in the judicial process, which will strengthen the case for signing up to the Caribbean Court of Justice. This is because the local judiciary will obtain a refreshed and positive public perception, because the people will see that things are moving in a positive and progressive direction. But until there is greater investment in local justice, which is visible to the majority of people in Trinidad and Tobago, the Caribbean Court of Justice will not be a priority for Trinidad and Tobago. Can I thank the Sanatana Dharma Mahasabha for the kind invitation to be with you here this morning.
Thank you very much, Mr. Anand Biharilal, Queen's Counsel, for your video presentation. And he remains live with us, Mr. Biharilal, virtually from the UK at this time. Our final presenter this morning is someone who really needs no introduction. His life, his work speak volumes as to his caliber. But when sometimes someone's accomplishments are so many, I think it's a fitting tribute to remind ourselves, and especially our younger ones, his magnanimous contributions to the field of law, politics, as a humanitarian, and to so many other spheres will always be indelibly engraved in our hearts and minds, and he continues as strong and as fierce as ever. To give us a short bio on his life and milestone achievements, I now call upon Miss Caitlin Damarsingh, a lower sixth student of the Lakshmi Girls Hindu College. Let's welcome her.
Sitaraman, good morning. Mr. Ramesh Lawrence Maharaj needs no introduction. He is a very popular senior counsel representing the citizens of Trinidad and Tobago on a daily basis. He was called to the bar of the Honourable Society of the Inner Temple in London, England in November 1966. He did his pupillage in London and returned to Trinidad and Tobago in 1967, where he was admitted to practice. Mr. Maharaj, as a practicing attorney at law, was involved in social work both at a community and national level, and he was very active in the human rights movement. Mr. Maharaj entered politics in 1991 and was a member of parliament. He also served in the opposition and in government as an opposition chief whip and as leader of government business respectively. Mr. Maharaj also served as an Attorney General and Minister of Legal Affairs. Mr. Maharaj has experienced the law from all sides, even as a litigant in the well-known cases of the Maharaj and the Attorney General No. 1 and Maharaj and the Attorney General No. 2. He also practiced law at all levels of the court system in Trinidad and Tobago, before courts in the Eastern Caribbean, the Caribbean Court of Justice, and before the Judicial Committee of the Privy Council. As Attorney General, Mr. Maharaj piloted in the Parliament several laws which promoted openness, transparency, and accountability in relation to governance. These laws included the Freedom of Information Act, the Equal Opportunity Act, and the Judicial Review Act. These laws have protected and they continue to protect the rights of ordinary citizens. He also piloted legislation to amend the Constitution of Trinidad and Tobago to reform the committee system of Parliament in order to make joint select committees of Parliament monitor and scrutinize ministries of government and all state agencies. As Attorney General and Minister of Legal Affairs, he has earned national, regional, and international recognition for his pivotal role in the establishment of the International Criminal Court, ICC, and was an influential figure at conferences in Rome, which led to the establishment of the ICC. In 2001, he was appointed on the ICC International Task Force to persuade world leaders to ratify the ICC Rome Convention. Other world figures of the ICC Task Force included former South African President Nelson Mandela, former United States President Jimmy Carter, South African Nobel laureate Desmond Tutu, and former UN Secretary General Boutros Ghali. As Attorney General, he was instrumental in establishing the Caribbean Court of Justice, CCJ. In January 1999, in Trinidad, he chaired the third special meeting of the Legal Affairs Committee, comprising ministers responsible for legal affairs and attorneys general of the Caribbean community, in which the attorneys general reaffirmed regional consensus for the establishment of the CCJ, which was eventually set up and headquartered in Trinidad and Tobago. Mr. Maharaj, as a practicing attorney at law, appeared in several cases in which landmark decisions were given, in particular constitutional and judicial review cases, in which the decisions in those cases contributed to the development of the law and the local, regional, and Commonwealth jurisprudence. Suras and the Attorney General of Trinidad and Tobago. This was a case where Parliament enacted the Equal Opportunity Act, but there was a change of government and the new government refused to proclaim the legislation. The Attorney General of Trinidad and Tobago and Dumas. This was a case where a public-spirited citizen believed that the President of Trinidad and Tobago did not follow the Constitution in satisfying the criteria for the appointment of members of the Police Service Commission. Vijay Maharaj and the Attorney General of Trinidad and Tobago. This was a case where the late Secretary General of the Mahasabha, Sri Satyanarayana Maharaj, was being prosecuted under the archaic and uncertain laws of sedition. The claimant succeeded in a claim in the High Court to strike out Sections 3 and 4 of the Sedition Act as unconstitutional. They argued that the sections were uncertain and contravened their right to freedom of expression. The court, in striking down the offended sections, held that they infringed citizens' free speech, expression, and thoughts. This case is presently before the Privy Council. And the list of cases goes on and on. Over the years, Mr. Maharaj has been a friend to the Mahasabha, advising upon and championing many of its causes. Ladies and gentlemen, I now welcome Mr. Ramesh Lawrence Maharaj, Senior Counsel, to address us.
Thank you. Sitaram and pleasant good morning to all Dharmacharya of the Republic of Trinidad and Tobago, His Holiness Pandit Dr. Ramprasad Parasram, Secretary General of the Sanatan Dharma Mahasabha, Sri Vijay Maharaj, President General of the Sanatan Dharma Mahasabha, Sri Krishna Rambally, Legal Advisor and Member of Parliament for Chaguanas West, Honorable Mr. Dinesh Rambally, Executive Members, respective pundits, esteemed panelists, all other persons, I observe all protocols, and all those who are listening on the radio or looking at TV on this program. I would first like to express my thanks and congratulations to the Sanatan Dharma Mahasabha for having this event, because I think it is very important for there to be public education on such an important issue. I think all of us would agree that the administration of justice is one of the most important issues or duties in any democratic country, because the justice system must be able to provide people with access to justice, and I think all of us would agree that the people must have trust and confidence in the administration of justice. As a young lawyer, that is something that I believed in, and that is something I fought for. I went throughout the length and breadth of Trinidad and Tobago advocating that our justice system should be a system in which people will have confidence in it. I criticized the administration of justice when it became necessary to do so. I criticized the parliament, I criticized governments when it became necessary to do so. If the Privy Council has to be removed as the final court of appeal for Trinidad and Tobago, I think the first set of persons, or the first step which has to be taken, is for the people to consent for that to happen. That cannot be done by merely a government sitting in parliament, or an opposition sitting in parliament, or lawyers sitting in the Hall of Justice. That the most important stakeholder in the administration of justice is the people. Every day in Trinidad and Tobago, whether it is a worker, whether it is a lawyer, whether it is a farmer, the administration of justice has some impact on that person's life. That person may have to go to the magistrate's court. That person may have to file an action in the High Court. That person may have to file an action in the High Court for trespass, the many kinds of action, breaches of contract. So the most important persons in the administration of justice is the people. And that is why I have always taken the position, and that is my position today, that if any government wants to abolish appeals to the Privy Council, they must first go to the people, get the consent of the people, hold a referendum, let the people vote on that issue, so that the people would be able to determine whether it wants the Privy Council to go or it wants the Privy Council to remain as the final court of appeal. You would have noticed from what was stated that when I became the Attorney General, I was involved in the plans to establish the Caribbean Court of Justice. I took the position then, and I take it now, that the Caribbean Court of Justice is an important institution because it provided two avenues for redress for justice in the Caribbean. It provided an original jurisdiction, which meant that if you had to interpret the CARICOM Treaty and matters like that, that court will be the court to interpret it. And I think there is wide consensus in the Caribbean that there can be no objection for the Caribbean Court of Justice having the original jurisdiction to interpret the treaty and for that purpose. In respect of the appellate jurisdiction, that is to say, as to whether the Caribbean Court of Justice would be the final court for Trinidad and Tobago, I took the position then that one can establish the Caribbean Court of Justice. Trinidad and Tobago should seat the Caribbean Court of Justice, but if the government had to decide whether it would abolish appeals to the Privy Council, that would have to be an issue for the people of Trinidad and Tobago to be determined at a referendum. So in 1999, when I served as Attorney General, I agreed and I recommended to the government of Trinidad and Tobago that we should be part of establishing the Caribbean Court of Justice for having the original jurisdiction. We made it clear then, and now as a private citizen, I am saying that was the position. We made it clear that if Trinidad and Tobago was to accede to the Caribbean Court of Justice as the final court of appeal, the government of Trinidad and Tobago at that time would not do that unless there was a referendum in Trinidad and Tobago called for that specific purpose and for the people to have a right to vote on that question. Now, in my contribution today, I want to try and explain this issue as best as I can so that the people of Trinidad and Tobago, in the short time I have, can understand this. And I notice that there are some students here, and I congratulate them for being there because they are the future leaders who will have to deal with some of these issues. When we say that the present position in Trinidad and Tobago in respect of final decisions in civil and criminal matters give to a litigant a right of appeal from the Court of Appeal to the Judicial Committee of the Privy Council, what we mean is this. If anybody has a dispute in a civil case is if you have two private individuals or private individuals filing a claim for like a breach of contract, a motor car accident, and things like that against an individual or against a company or against a government. So there can be a civil case against a private individual or a civil case against the government. So like, let's say the police arrest someone and charge that person, and then the person gets off, was acquitted. The person can then file an action for damages against the state and the police. That is a civil case. When the police charges an individual for criminal offense, to say that he breaks in or he enters, he stole something, that is a criminal offense. But when you file a claim to recover damages, to get some civil remedy, that would be a civil case. So right now in Trinidad and Tobago, if anyone has a civil case, and that case is determined in the High Court, the person then has a right of appeal to go to the Court of Appeal. But if you want a further appeal, the Constitution, if that case is above $1,500 worth, the citizen has a right of appeal to take that appeal to the Judicial Committee of the Privy Council. And the Privy Council is the final court of appeal for Trinidad and Tobago. When the Privy Council decides that case, that is the end of the matter. If someone is convicted for a criminal offense in the High Court, then the person has a right of appeal to go to the Court of Appeal. And if the Court of Appeal decides one way or the other, there's a further appeal with leave of the Privy Council to the Judicial Committee of the Privy Council. So that is the appeal system that the Privy Council operates on. Now, you would have heard Mr. Harilal mention a case of Maharaj and the Attorney General. Fortunately or unfortunately, that was this individual. What happened in 1975, as a young lawyer, just about 7 years as a lawyer, I had a few cases before a judge called Justice Sunny Maharaj. I have always understood that a lawyer's job is to do justice, is to fight for justice for his client. And even if the judge is misbehaving, the lawyer is supposed to protest against that injustice. So this judge was dismissing cases unfairly against my client. And I went before the judge and I told the judge, my lord, that you have been behaving unjudicially against my clients and you are guilty of unjudicial conduct. Everybody in the courthouse was afraid. They figure you can't talk to a judge like that. In my view, I was entitled to protest the injustice against the judge. Well, the judge sentenced me to 7 days simple imprisonment. So I went to the San Fernando police station escorted by a police officer. And by the time it reached the news in 1975, in April 1975, a lot of people were outside the San Fernando police station, but also a lot of lawyers came to me. And they said, you know, Ramesh, we spoke to the judge, and if you apologize to the judge, he will rescind the order and you could go free. I told a particular lawyer, I wouldn't call his name today, but I told a particular lawyer, go back to the judge and tell the judge that if he asks me to come back before him, instead of getting 7 days, I would ask him to give me 14 days simple imprisonment. I told the lawyer that I understood my job to be fighting for my clients and fighting for the administration of justice. And I'm not prepared to apologize to the judge, because if I apologize to the judge, every lawyer after me would have to apologize. By the time I reached the Royal Jail in San Fernando, in Port of Spain, lawyers came to me and wanted me to apologize. I took the position that the independence of lawyers must be fearless in the discharge of their duties. Well, the judge did not agree with me. The Court of Appeal did not agree with me. And at that time in Trinidad and Tobago, there was no right of appeal in contempt cases. If you were convicted for contempt, there was no right of appeal. So I petitioned the Judicial Committee of the Privy Council, because that was the final court of appeal. And the Judicial Committee of the Privy Council decided to hear the case. The Judicial Committee of the Privy Council heard the case, and they found that the judge was wrong. And the Privy Council set aside the conviction of 7 days simple imprisonment. But I decided that this must not end there. There must be a future. The law must be developed. So under the Constitution of Trinidad and Tobago, if anybody's right is infringed, that person can file a claim before the High Court, and the High Court will have the power to declare that the right was infringed and to order compensation for the violation of that right. So I went to the High Court and I filed a claim alleging that the state violated my right, the state of Trinidad and Tobago violated my right, because the judge is part of the judicial arm of the state. And therefore, if the judicial arm of the state violated my right, the judge may not be liable, but the state was liable to pay compensation to me. Well, I went to the High Court. The High Court felt, well, they never heard of this law before. So they dismissed my case, went to the Court of Appeal. Court of Appeal dismissed my case. There was one judge in the Court of Appeal, though, Justice of Appeal Clement Phillip. He decided that no one was above the law, not even the judge. And he dissented, he gave a dissenting judgment and said if it were left to him alone, he would have held the state liable and ordered the state to pay compensation. The matter went to the Judicial Committee of the Privy Council, and the Privy Council decided in my favor. The importance of that case and the development of the law in that case is since then, it means that even if a judge violates your right, violates your fundamental right, that judge is not above the law. The state is liable to pay compensation to you if as a result of the order of the judge, a citizen's right is infringed. So, I am telling you that because I think it is a good way to illustrate that the people are the most important stakeholder in the administration of justice. And that, I must confess, had influenced my thinking over the years that not that the Judicial Committee of the Privy Council cannot be removed as a court of appeal for Trinidad and Tobago. I believe at some time in the future history of Trinidad and Tobago, it may be 10 years, it may be 50 years, it may be 20 years, the Privy Council will ultimately be removed as the final court of appeal for Trinidad and Tobago. I do not see this issue as an issue of a competition between the judges in the Privy Council or a competition between the judges in the Caribbean Court of Justice. There are very distinguished judges and jurists in the Caribbean Court of Justice. I could think of many. Sir Dennis Byron, who was president of the Caribbean Court of Justice. Adrian Saunders, Justice Adrian Saunders, Michael Labastide. Right now you have a very good number of judges, very distinguished judges. There are also very distinguished judges in the Judicial Committee of the Privy Council. I see this as an issue in which the condition precedent, the first step for any government to decide to move, in order to remove the Privy Council, you must first get the consent of the people. And that was the advice I gave to the government of the day in 1995, when the government decided that it would accede by having the Caribbean Court of Justice site established in Trinidad and Tobago, that we would accede to the original jurisdiction, but before you can accede to the appellate jurisdiction, a government must hold a referendum for the people to vote, for the people to decide, because when you have such a referendum, the people would hear both sides, the people would know what they experience with the administration of justice, and they would decide whether they want that or they do not want it. Now, I want you to know that the government at the present time, the present government, does not have the requisite majority in the Parliament to remove the Judicial Committee of the Privy Council. In order to remove the Judicial Committee of the Privy Council as the final appeal court for Trinidad and Tobago, the government would need 3/4 votes of the number of votes in the House of Representatives, and it would need 2/3 of the votes in the Senate. If my mathematics is correct, 3/4 of 41 is 31 votes. Right now the government, I think, has 22 votes in the House of Representatives. So it is 9 votes short. In the Senate, it will be 2/3 of 31, so that is 21 votes. The government has 15 votes. It would need 6 independent votes in order to get it going. So that the present government and a lot of the governments in the past did not have the majority, and this government does not have the majority. The government has not taken a position during this term that I am aware of that it intends to go to Parliament in order to remove the Privy Council. So I do not think at the present time there is any threat that the Privy Council would be removed as the final court of appeal for Trinidad and Tobago. But it is very important for us to do what we are doing now, for the people to know both sides of the coin, because at the end of the day, it's the people, I think, who would play a very important part in determining whether the Privy Council remains or it does not remain. Now, Mr. Harilal also mentioned something that I intended to mention, and I just want to expand on it a little. In the short history, in respect of the Caribbean, in respect of the Privy Council as the final court of appeal for Trinidad and Tobago, when we got independence in 1962, the government of the day agreed for the Privy Council to be the final court of appeal. When we moved from independent status in 1962 to 1976, I was a young lawyer in those days, in 1976, and I remember upon the time when we were becoming a republic, there was a lot of discussion as to whether Trinidad and Tobago as a republic should keep the Judicial Committee of the Privy Council. And there was a joint select committee of the Parliament appointed to hear the public views. The party in government at the time, the People's National Movement, had taken the view that the Judicial Committee of the Privy Council should be removed and replaced with a federal court or a Caribbean court. What was very important, however, that there were lots of discussions, lots of agitations on both sides, and one of the major arguments was that you could not be a republic if you still had appeals to the Judicial Committee of the Privy Council. And Mr. Anand Biharilal mentioned it. Dr. Eric Williams, who is regarded, and he is the father of the nation, and he was the political leader of the People's National Movement, and he disagreed with his party. He took the position, words to the effect, and Mr. Biharilal quoted it, Trinidad and Tobago is a small country. Everybody know everybody. And he mentioned, if I remember correctly, words to the effect, you go to a cocktail party, you see everybody. Everybody there, judge, parliamentarians, everybody. And he took the position that justice must not only be done, but must appear to be done. And he took the position that notwithstanding Trinidad and Tobago was going to become a republic, and I think he had all the seats in the parliament because there was a no-vote campaign, and he had all the seats in the parliament. He had all the majority to remove it. He decided that in the interest of the people of Trinidad and Tobago, the Judicial Committee of the Privy Council should remain as the final court of appeal. That is why I am reinforced in my view that if we want to remove it, we can remove it. But the people who have to decide to remove it is not members of a government or members of an opposition. There must be legitimacy. And the only way you could have legitimacy is by having a referendum for the people to vote on that question. So, my contribution today is I want to take a practical approach to this. The Judicial Committee of the Privy Council has been the final court of appeal for Trinidad and Tobago for 189 years. It is the final court of appeal since 1833. So, having regard to that period of time, it has served the people of Trinidad and Tobago. Having regard to what I have told you, having regard, and if you forget the competition between the Caribbean Court of Justice and the Privy Council, forget the judges. Forget that for the time being. Because I do not like the idea of comparing, well, not that I do not like, I think it's not important at this stage to discuss as to whether the judges are better and the judges are not better. I think the important question is, what is the constitutional process a government must use in order to uphold the principle that democracy, simply defined, is government of the people, by the people, and for the people. And if a government is interested in serving the people, in my view, a government would want to have a referendum to be able to get that decision from the people before it makes a decision to decide that it is going to pass a law to remove the Privy Council as the final Court of Appeal. Now, it is not an excuse for governments to say, well, we do not have any existing law now to permit a referendum. Referendums are used in countries as a constitutional process whenever a government believes there's going to be a major change of policy. So if you have a final Court of Appeal for 189 years, then it would seem to me that it's going to be a major shift in policy. And it seems to me that a government should always be advised in those circumstances that you cannot take this step unless you decide to have a vote of the people on this issue. And so referendums are recognized as a process for that to be used. And let me give you some of the positive features of governments in using referendums to decide an issue of policy. It is said that referendums enhance democracy, and this is what governments have found over the years from the studies. Referendums enhance democracy by giving voters opportunities to participate and to be directly involved in the decision making in the country. That is for the people to enjoy participatory democracy. Referendums are considered to be pure democracy as a reminder that democratic authority finds its legitimacy in the consent of the people. Referendums are used by governments to settle a debate on controversial issues which arise in the country. Referendums provide to governments a mandate to undertake change and to provide parliaments with an indication of public opinion on any given issue. Referendums are important tools for governments because it makes governments aware of the volume of public support for a particular issue or policy so that government can determine whether to implement the policy or reverse the policy. Referendums are regarded as protective devices for the rights of the people, as a safeguard against controversial decisions being taken by governments until public support for those decisions can be demonstrated by a vote of the people. Now, in the Caribbean, there have been 8 attempts by governments to abolish appeals to the Privy Council by the use of using a referendum. There have been 8 attempts. In 7 of those referendums, the people voted against the abolition of appeals to the Privy Council. In 1, they voted for, and I will give you them. In the Bahamas in 2002 and 2016, the people voted against the abolition of peace to the Judicial Committee of the Privy Council. In Antigua and Barbuda, in 2008, the people voted against the abolition of appeals to the Privy Council. In Nevis, in 1998, the people voted against the abolition of appeals to the Privy Council. In Grenada, in 2009 and 2016, people voted against the abolition of appeals to the Privy Council. In St. Vincent and the Grenadines, in 2009, the people voted against the abolition of appeals to the Privy Council. The only time that happened in the Caribbean was in 1978 under Forbes Burnham, when there was a lot of reports in all the newspapers and by governments that that was a rigged vote in Guyana. Now, I do not know how many of you remember the history of Burnham in Guyana, but at that time, under Burnham in Guyana, Burnham was flying on the party headquarters. He was flying on the courts of Guyana, the party flag. And he was known for not following democratic principles. Now, in the Caribbean, in some of these countries, or in most of these countries, they provide for a referendum. And that is why I'm saying that even if you do not provide for a referendum, all the government needs in Trinidad and Tobago is a single vote, simple majority, to have a law to provide for a referendum if it wants to have a referendum before it decides to have Parliament determine whether to abolish appeals to the Privy Council. So, I just want to pray in aid Section 1 of the Constitution of Trinidad and Tobago. And that provision I think you are very familiar with. It says Trinidad and Tobago shall be a sovereign democratic state. Let me explain to you what that means in my respectful view. In 1962, when we became an independent country, the Queen was the head of state, and that is known as a monarchy. In Britain, you had a monarchical form of government. The Queen was the head of state. So the sovereignty of Trinidad and Tobago in those days belonged or resided in the Queen. That means that all the power of the people is represented by the Queen having all the power of the people. In 1976, when we became a republic country, the Queen was no longer the head of state, and there was a new provision in our Constitution of 1976, Section 1, which says Trinidad and Tobago shall be a sovereign democratic state. That means that the sovereignty of Trinidad and Tobago does not reside in the President or the Prime Minister or the Parliament or the Cabinet or the opposition. It resides in the people of Trinidad and Tobago. The people have all the power in Trinidad and Tobago. The people could move a government, could replace a government, can virtually do anything lawfully in Trinidad and Tobago. So that is why I say that if it is that for 189 years you have a judicial institution giving you the appellate jurisdiction, and yes, you recognize that at some time in the future you may have to get rid of it because of many reasons. But that is not the point. The point is that if you want to take away that right of the people, because in Trinidad and Tobago at this time, you have a constitutional right given in the Constitution
to have appeals to the Judicial Committee of the Privy Council. That is an entrenched right. It cannot be taken away except by a special majority vote in both houses of Parliament. So if you forget the constitutional law for the time being, and if you are a government committed to democracy, and you want to remove that right, and the people of Trinidad and Tobago, sovereign democratic state, then it only follows that you have a duty as a government to consult the people, get the consent of the people, and you pass a law to permit a referendum and permit a vote for that purpose. Now, it may be, I'm not giving an opinion on this, it may be that if any government, I'm not saying this government, if any government, because I think at one time the leader, the Prime Minister of the partnership government had expressed the view that she was thinking of removing the Privy Council. I hope my memory serves me right. I think that. So if any government decides that it is going to do that without a referendum, it may be that public interest litigation can be laid against that government as a breach of public law principles, of it being irrational and of it being not fair and of being unlawful. So I say this because it is very important, and I feel very privileged to have been here this morning to share my thoughts with you. I feel very strongly about this issue. I remember when I served as Attorney General and I had to determine this issue, I believe that I was doing, and I think I did the right thing by agreeing that the Caribbean Court, by recommending, by advising the government that we should seek the court in Trinidad and Tobago. The court is a good court for the original jurisdiction, and I believe, and I want to say this, I think in a short space of time that the court has been there, I think the court has given very important decisions, and they have demonstrated that the court is competent. But that is not the issue in my view. The issue is that this is not something for members of parliament alone. This is something for the people. Because I want to tell you something. When a person goes to court and he gets an injustice, he or she gets an injustice, and he or she feels the pangs of that injustice, and he or she suffers because of those injustices done to him or her, or he or she sees that, or believes, or have a perception that the justice system was manipulated against him or her, that person would obviously have some distrust of the administration of justice. And that is why it is important in any society for the administration of justice to be pure. There must be no doubts about it. Judges must behave in a way in which their conduct can be scrutinized by the public, and the public would have confidence in it. The judges must be independent and fearless. They have security of tenure. No one, not the president, nor the prime minister, nor the chief justice, must be able to violate the security of tenure of a judge. Judges must live certain lives in a way in which the public would respect them. In any society, a chief justice and judges must live a life in which the people would have confidence in it. So, in closing, I have got a lot of comfort over the years in the statement made by the then Prime Minister of Trinidad and Tobago, Dr. Eric Williams, in 1976, when he had all the power in Trinidad and Tobago. He had omnipotent power. He could have removed the Privy Council, and he was a gentleman that I had very high respect for. He said, our country is a small country. We live in a small society. Everybody know everybody. These are not his exact words, but words to that effect. And it is for the benefit of the country, for Trinidad and Tobago, to retain appeals to the Judicial Committee of the Privy. Thank you very much.
Thank you so much, Mr. Ramesh Lawrence Maharaj, Senior Counsel, for your thorough, perceptive, intellectual, thought-provoking, and expert presentation and delivery on a truly intense and important topic. He is truly a people's advocate. I'm sure by now, friends, those of you who are with us in person today and those looking on and listening on via radio and TV, Jaguarty, and social media now have a better understanding of today's seminar themed the wide-reaching significance of the final appellate court for Trinidad and Tobago. We hope you have found the discussions insightful, and there's no doubt that further discussions will be forthcoming. In the days and weeks to come. So we're almost at the end of our seminar, but as part of our final segment, I was just informed, we'd like to get a little bit interactive with you and open the floor for questions from members of the media. We've got our media presence with us, we've got specially invited guests, we've got our students of some of our SDMS schools, and also members of the public. So now you can feel free to pose your questions to any presenter on stage you've heard from thus far. I'm sure they'd be able to, as best they can, share further thoughts and bring further clarity to the issues at hand. I believe we've got a cordless mic, so you can simply indicate by raising your hand if you have a question to pose.
Morning. Good afternoon. The question I have is indirectly related to the question of retaining the judicial appeal to the Privy Council. The substantive issue seems to be a lack of faith in the judiciary and a lack of faith in institutions generally. So I want to ask the attorneys and Ms. Nunez, who is also involved in legal education, does the judiciary engage in any kind of self-reflection which leads to reform? That's the first thing. And the second thing is, are these issues contemplated in the education of lawyers? Because I have had some experiences with locally assembled lawyers, too much. I have been before the courts as a person, as bringing matters, too much for one individual, I find. And I find the perspective that is brought to the matters, and I've been to court as a reporter, and I've seen how the judiciary handles people of different social classes. So the question is, the education of lawyers who become judges, does it contemplate these issues?
Well, I think Justice Kokram heads up the Judicial Education Institute, so that I know that all judges are expected and do participate in that judicial education and address those issues. Of course, I'm not a judge, so I'm not privy to the inner workings. But I will say that the major concern, I believe, is not the quality of the judges. I think Mr. Maharaj spoke to that. I don't think there's a concern that we don't have judges of the caliber, but there is this continuing concern, perhaps not unreasonable, as Justice Jamidar said, of perhaps that concern about whether your matter will be fairly addressed. And it may not come just from the judiciary, it may come from the whole system itself, which is why I think the checks and balances that they've put in place for the CCJ should help significantly in allaying those fears. But it is not unreasonable to have those concerns. I would agree with that.
Sorry, part two. What about generating data? Because we've heard some references to cases that have gone before the Privy Council, but I don't think it's unreasonable to ask, well, how many and of what importance? I haven't heard that, and that information is not readily available. I haven't seen a thought out response to the importance of the Privy Council in those terms.
Well, I, in a way, alluded to that, but perhaps maybe a little short notice, but you can find it. If you go to the Judicial Committee website, they have decided cases, and you can actually go through, which I started doing. I went up to 2019, and I saw how many cases came from Trinidad, and then I looked to see how many of the cases the appeal was dismissed or was allowed. And in the, I wouldn't want to say the vast majority, but in a significant majority of the cases, the appeals were dismissed, meaning that the Privy Council sided with the respondent, which means that they sided with the Court of Appeal. Now, I did not go back far enough, it is true, but I think with a bit of 2-3 hours, the information at least is there about the cases, who are the litigants, and the outcome of those cases. You will find it. But what did strike me, as I said in my contribution, was that comes back to the access to justice point. Nearly all the litigants at the appeal stage were either the government or government bodies or private enterprise, and that has, in my respectful opinion, has to do with the cost of taking a matter to the Privy Council in London. And just by way of correction, I heard, I know I shouldn't say by way of correction, but it had been brought to my attention before that because of COVID-19, the Privy Council started having virtual hearings so that you avoided those costs. And they did that, but I think on the 23rd of October last year, they reverted to in-house hearings. So they've gone back to the status quo of having the litigants appear in court to have their matters heard. Huh? Yeah, we have asked for hybrid hearing in my matter. I know my gentleman who represents the other side is there, but it doesn't mean that you'll succeed because I've heard no word. You've had one. And the reason was my initial hearing was January, and then whatever, it's gone to July. And we have asked for hybrid hearing because it is true for me personally, I mean, whatever people may think, I did not, the Court of Appeal, once I won at the Court of Appeal, I got nothing. I had to now defend myself at the Privy Council whether I wanted to or not, because once the appeal was launched, if I did not defend, then they would get judgment against me. So I had to put myself, no offense to the thing that they're doing their job, but it put me at tremendous cost. And so that when the virtual hearing was initiated and my matter was to be heard in January, I was very happy. But we have asked for hybrid hearing, and I'm hoping that today I will be given that hybrid hearing. I know Mr. Biharilal is in the appeal against me, so I know he's listening, so, huh? He's no longer? Oh, sorry, Mr. Biharilal, I thought you were still in the matter. But in any event, my apologies. But I am hoping and praying that I will be given the hybrid hearing, because it costs to me, regardless of what people may think, it is unbelievable. And by the way, my lawyers are not charging me. I just want to say, my lawyers are not charging me. So these costs are not costs of my legal fees for my lawyers, but probably they feel sorry for me, right? But this is the cost of going to that courtroom in London.
Check 1, 2. Thank you so much, Ms. Karen Nunez Teixeira. And we've got another question from a member of the audience. You can tell us which panelist you'd like to pose your question to.
Well, I would like to pose my question to all of them. I'm a lay person. My name is Pandit Jagannath Sira Maharaj, former lecturer and also a former manager at Petrotrin, the corporate HSE manager, who was retired in 2017. I want to say, and I want to ask, do we have an increasing trends currently or in the past of cases that have been to the Privy Council, or is it that it is not increasing, or we are having less than the past? That's one. And if so, why? Do we have separation of powers in the judiciary and the executive and also of the legislative arm of the government? And I would like to include now, I have seen, I would like to say that I support the judiciary of what they do, but I also, of Trinidad and Tobago, but some of the decisions that comes out, we wonder as a lay person what really goes on. There are scientific information which present in some cases, and we utterly, the people, the citizens, are utterly disturbed of some of the information. Some of those things I would like to reflect upon. Take for example, our cremation, that which this we cannot pass as a pundit. We see the treatment which was meted out to us, and it makes me remember my former Secretary General, and I worked very close with him because I was also a member for many, many years as an executive member. And he indicated, he said, Pandit, anytime you see an idea of something said or done, take it up. There's a lot more in that to come. And we saw it with the cremation. And if we do nothing, then great men who sit quietly and do nothing will bring great destruction to these young children. Another thing, the radio license of the Mahasabha and the TV license, we suffered. But while people, you all three spoke of it, while we are all four, while we're suffering, who compensated that suffering? The deterioration of the aspirations of young people to get opportunities was not given in many, many areas. Do you think it's right to wait for a divorce for 13 years in the court? Recently, pension. I retired in 2017. And that now, we were guaranteed a medical plan. And that have jeopardized. For 40 years, I paid that money. And we come and the government states now, we cannot get. So we have to pay the pension, and you're paying a new plan. And yesterday, I was told by which that plan governs and pay for us, we no longer can get the benefit of the plan, even though that you are paying for it. You have to take your money and pay for it. So I'm saying to you, these are some instances that every day occurs to citizens like myself and other people in this country. How can we say we want to relieve, depend on the courts, but don't have another place to address the issues. And I don't figure, if we cannot agree to simple things in the Caribbean, culture different from Barbados to Trinidad, culture different in the Mahasabha, and it different in another place. The environment different also, and the systems different. And if we cannot recognize these things, then we cannot go. I want your comments on these. Thanks.
All right, maybe we can ask Mr. Maharaj, Senior Counsel, to just give, I think the questions may have been lost in the commentary, but Mr. Maharaj, any closing remarks with respect to that?
Well, I think a lot of the comments from Panditji were not questions, were really comments on matters which are not about the courts and the Privy Council. With respect to Petrotrin matters and etc., we can't really comment on that. I don't know about that. In respect of, he mentioned about the court having delays in the administration of justice, and that in some cases the public do not understand some of the judgments that are given. Well, I think that those are very good points, because those are some of the complaints that people have about the administration of justice. And over the years, there have been committees, commissions of inquiries into those matters, and there have been reports, and really and truly it has to do with implementation of some of those plans. But in respect of those questions, if I may say, it didn't really have an impact on the question of appeals to the Privy Council and abolition of appeals to the Privy Council. But I think they are relevant to having a very good administration of justice.
Thank you, Mr. Maharaj. And if I may just ask Mr. Anand Biharilal, Queen's Counsel, if he has any thoughts, because he has been arguing a lot of the local matters, domestic matters, disputes which have been adjudicated upon, and he's arguing them before the Privy Council as well. Mr. Biharilal? Okay, I think we are able to hear you now, Mr. Biharilal.
Hello? Hello?
Yes.
All right. I hope that, let me address what generally Panditji was asking about. What I had said in my contribution, which I know the video went a bit funny at the end, but essentially what it comes back to is the efficiency of the local public institutions of Trinidad and Tobago. Whether you're dealing with pensions, the provision of water, or delays in the courts, it is a question of the assignment of resources. The Caribbean Court of Justice, and acceding to it, will not solve any of the problems you have mentioned. What will solve those problems is real investment in making those institutions work, ensuring that the people who staff those institutions are people of integrity, so that they are serving the people rather than taking a paycheck with a great desire for the day to end without doing very much. When it comes to the courts and delays, it is a serious problem. There is a case in which I am involved where a mother and son who were making an appeal to the Court of Appeal died from COVID whilst waiting for judgment. It's now been about 2 years, and we do not have judgment yet. What is needed is an increase in the number of judges and greater accountability, not just on doing the job properly, but the time efficiency when we get decisions. A question was asked earlier in relation to whether the judges are accountable to how they conduct themselves in their professional lives, in their personal lives, and so forth. And I think the gentleman who was speaking may have been a reporter who has attended a number of hearings and seen how people are treated and spoken to. This was why I mentioned the principle of dealing with people courteously. Because whatever decision you make, it's going to affect their lives. If you treat them unfairly, even if you come to the correct decision in their case, they will not see it, and nor will the public. And that is what we mean when we say in the law that justice must not only be done, but it must be seen to be done. And coming back to the judiciary, it is correct that the Caribbean Court of Justice has principles of conduct, but so too does the judiciary of Trinidad and Tobago. And it is available for people to look at. It is called the Statements of Principle and Guidelines for Judicial Conduct, published in 2017. Though I suspect that if you compare some of the principles in that document to what the first speaker or questioner may have seen for himself, may find that there is a disconnect between the principles and the practice. But it is right that there is a set of principles that should be adhered to. But again, it comes back to the dysfunctionality or functionality of public institutions. You can't have principles and not strictly require them to be adhered to. And there has to be a connection between the two. And if we can resolve those kinds of things in Trinidad and Tobago, it will go a long way into boosting confidence in public institutions and ultimately the Caribbean Court of Justice. So I hope that's helpful.
I would like to thank Mr. Biharilal QC, of course, for those comments. Very insightful. Are there any other questions? I know we have a lot of attorneys in the audience, and at this time I would want to recognize a very senior attorney with us, Mr. Darrell Allaha, and I know he would want to share a few thoughts with us, if not pose some questions.
Thank you, Dinesh. Good afternoon, everyone. I just want to say that I appreciate all of the points that were made by everyone on the panel this morning. We surely have gotten this morning some food for thought, and my comments are not legal, certainly not academic, but they deal with public perception. I always found it, we have heard the arguments time and again, and one of the main arguments, or two of the main arguments, I think Kyle had mentioned them, were sovereignty and the final cutting of colonial ties. And those are very deep arguments, and they're arguments that are used quite frequently. But as speaking for myself, now I'm an attorney, but if I put myself in the position of a layman, I would be very confused, and I would give you some observations and maybe throw them out to the panel to get their thoughts on it, and I'd appreciate it. One of the observations is that quite a few of the judges on the Caribbean Court of Justice come from territories that still have the Queen as the head of state. And I think that makes a difference in terms of perception, because we hear arguments about cutting colonial ties and sovereignty, and quite a number of them come from territories where this Queen is still the head of state. And we can get into all sorts of arguments about culture and about perceptions and jurisprudence. I'm not going to get personal. The other one is the other one I find is a bit amusing, and that is that for many years we talk about colonial ties and breaking the Queen and the hegemony of the British and cutting all of that colonial history. For many years, the president of the CCJ carried a knighthood. And I find it so ironic and hilarious that and I'm not being personal, that we talk about the CCJ as our own Caribbean court, and for many years the president was Sir Dennis Byron. So I think we're sending mixed signals, and as Caribbean people, we probably don't know what we want. We want to keep colonial institutions of status and keep our knighthoods, Sir Dennis Byron, and at the same time we want to say Caribbean jurisprudence as CCJ. I don't know if the panel can respond to these observations. Thank you.
This one I will ask either Mr. Maharaj, and as senior counsel, he could of course hand it over to junior Mr. Kyle Tacklalsingh if he so wishes.
Well, I don't see anything inconsistent with Sir Dennis Byron being the president of the Caribbean Court of Justice, whether he got a knighthood before or afterwards. I look at it in a different context. I look at it, what is the substance of the matter. I know that there could be arguments of that, the perception of how it looks and etc. But let us be practical. We are a republic country, and we have judges in Britain who are sirs and all kinds of things, and they adjudicate on our matters. And I do not see that as a reason really, because they have a knighthood and etc. And we can't get away from the fact that Sir Dennis Byron is a distinguished world jurist. He is a distinguished jurist. He is well recognized. So I would not place too much emphasis on that, even though some people may. That's the only one I think I want to respond to, Daryl.
I may say something on that, but it might sound a little bit, what should I say, rebellious, maybe. It's the least they could do. It's the least that they owe us. It is so strange that you have that conversation, we're having this conversation, because only yesterday with someone who lives in St. Vincent said to me how they were so angry with the Prince William and Kate, and they were so upset about the whole thing. I think it was Prince Edward's, and they expressed their view, and I think they knew what they were talking about, that the Prime Minister left the country coincidentally at the same time as Prince Edward was there. But the view is, maybe it's a form of reparations. You know, you want to give me recognition? Well, we work for that recognition. So I see it in a different way. I don't see it as bowing to the powers that be, but I see it rather that as the least that they could do for what we have been put through. Now, if as an independent sovereign state we take it, that's a different thing. But St. Vincent is not in that position, and I think Dennis Byron from St. Kitts was not in that position at the time. So I think that's the least they could do, and I would look at it a little differently than you do.
Okay, I see one hand up in the audience, but I want to just hand over to Mr. Biharilal QC to comment at this point in time.
Well, it perhaps illustrates that this colonialism issue is just a non-issue. We are in 2022, not 1822. So things are very different. We have to look at the world as they are today. And as far as Sir Dennis Byron is concerned, I agree with Ramesh. He's a distinguished jurist. That was his title, as he's entitled to have it. And he proudly displayed it. But it should not be thought that this is something that is only associated with Sir Dennis. People may forget, because memories are short, that Carl Hudson Phillips, Queen's Counsel, retained his title Queen's Counsel even after Trinidad became a republic. He didn't convert it to Senior Counsel, although I know the Law Association has converted my certificate to Senior Counsel. And also remember Sir Ellis Clark, the first president of Trinidad and Tobago. When he stood down as president, he reverted to using his title Sir Ellis Clark. So what I would say is that the issue of colonialism is a non-issue. And if it was so strong an issue, the language we have inherited from England, English, we wouldn't be speaking now. We might have conducted this seminar in Hindi or Bhojpuri. So I hope that helps.
So I would like to thank Mr. Biharilal, Mr. Kyle Tacklalsingh.
Yes, I would just jump in there to simply say this, that I take the point to some extent in that if the only good reason that is being advanced or is being articulated, whether that be that the arguments for it are simply not strong enough or it's not being articulated properly, is that a Caribbean Court of Justice is to give us some type of symbolism or is merely an icon, then those who serve may also have to give up the symbolism and icon as well. And it's not to say I'm calling on anybody to give up any title. It's to demonstrate that the argument that the CCJ is somehow representative of an entire Caribbean culture is wrong and facetious, and I don't accept it. And that's my view.
Thank you, Mr. Tacklalsingh. I know Mr. Ramcharita.
I did not introduce myself the last time. I'm Raymond Ramcharita. I've done some work in culture and history, and I want to be very respectful to the panel. You are using 19th century and 20th century language to discuss a 21st century problem. Notions of the nation state, sovereignty, culture, they don't mean what you think they do. Those terms do not mean what you think they mean. So this is what I was alluding to in terms of the education of jurists. So maybe you could look at that for a future occasion where the epistemic and interpretational dimension, the social dimension, not the legal dimension, because that seems to be the sticking point. Emotion, symbolism, culture, those are wildly abused terms in Trinidad and Tobago and elsewhere. So that's my respectful contribution.
Thank you, Mr. Ramcharita. He has been here from the very inception of today's proceedings. I want to ask Dr. Bhushan Singh, who is present as well. He has some comments or questions he would want to raise.
Thank you very much. Thank you to the esteemed panelists. A very informative session. I want to first say, I have no knowledge of the judiciary. I have no knowledge of the law. I come to forums like this to learn whatever little I know and what I read on the newspapers. And Mr. Maharaj, coincidentally, I read a book when I was in high school by Master Berlin's, Barrister Behind Bars. And what struck me then, the Court of Appeal and so on in Trinidad, all the courts in Trinidad, the attorneys in Trinidad had a point of view. To change that point of view, you had to go to the Privy Council. a different mindset. Moving to present time, you said that Dr. Eric Williams said that Trinidad is a small society. Everybody knows everybody, some connection somewhere. That's what we live in. That's what we have to face. And having said that, in the press not too long ago, in the judiciary, there seems to be a big rift. It was played out in the press. Who knows if that rift is still there or if it has been cemented over. We don't know. There's a lot of, lack of transparency. And this lack of transparency erodes trust. Now, that is for the judiciary in Trinidad and Tobago. And my layman's point of view with regard to the CCJ, they might have very eminent judges, I don't know. What is the recourse? You spoke about the power of the people. The people could remove the government. The power lies in the people. I don't know what sovereignty means in the legal terms, and so I can't discuss that. But if you said the power lies in the people, when we see behavior like that, that doesn't bring confidence to me in the judiciary or the CCJ. I don't know how they appoint judges or what. What is the recourse of the people? Do we have a recourse, or is the judiciary untouchable? Could do what they want. This is where my lack of confidence lies. Thank you very much.
The judiciary is not untouchable. Quite apart from people having a right of appeal in respect of the legal issue, it has been held by the highest court of Trinidad and Tobago since 1936 in a famous case of Ambad and the Attorney General that the administration of justice is not a cloistered virtue. It can be criticized. People are entitled to criticize it. Now, if there is how the system works is that the people have the power at election time to keep a government or to remove a government. If for some reason the government is kept or the government is removed, but during the 5 years we do not have a system in our constitution that the people can go at any time and vote for a general election to be called. Our system is based on a 5-year term for a government. But if during the period of 5 years there are problems which affect either the administration of justice or the government, that is why you have an opposition party. And the opposition party is supposed to be the alternative government in the parliament. What you have in addition to that is that over the years there are certain laws which have been passed which have given the individual in Trinidad and Tobago the right to get government-held information. So we have a Freedom of Information Act, in which even if the state refuses to supply you the information, the court has the overall power. But I know what you want to come to. The judiciary is sometimes regarded as a sacred cow, and therefore people have to be very careful how you criticize it and what you say, because if members of parliament raise things in parliament, it can appear as if they're interfering with the separation of powers. And that is why you have a law association. The law association is supposed to be a very powerful organization taking up the problems on legal issues and keeping the judicial arm of the state in check. The law association of the country is really should be a mouthpiece for the population if they have to take up anything which affects the administration of justice. So really and truly, this may be a time in the history where you need a very strong law association, but you also need a very strong legal profession. I'm going to say something now that it may be very controversial. lawyers play a very important role in ensuring the rule of law is upheld, democracy is maintained. Lawyers supposed to be a kind of guardian of society, to take up important matters, to criticize the government of the day, and to be prepared to make sacrifices. And that is why in the olden days you had probably many more lawyers getting involved in activities. I remember when I was a younger lawyer, I went all over the country giving speeches, marching. I marched from Cedras to Port of Spain, all sorts of things. I see that the legal profession should be more proactive in protecting the public and in taking up the rights of the people. Okay, I hope I answered your question.
I just want to hand over to Mr. Biharilal QC. I know he wanted to share a few comments at this time.
I think the first thing is that in relation to what Ramesh has said, I'm in 100% agreement. In addition, the specific questions about judges, there are processes that can be employed to remove a judge for serious misconduct. And I know it may be still in relatively recent memory, the impeachment hearing that was brought against former Chief Justice, the late Chief Justice Sharma. But that is a very extreme procedure. There should be something in place that sits beneath that. And so I would favor a reform of the law in relation to judges' discipline. That if there is conduct that falls short of removal and falls short of simply allowing an appeal against their decision, for example, they were rude to a litigant, there should be a process whereby a disciplinary procedure could be made or a complaints procedure could be made. But these are the kinds of things that the government of the day that controls the legislative agenda has to look at. And the opposition can call for it to look at. So too can the Law Association. And if there was a revised system, perhaps a complaints tribunal, which could result, I don't know, in types of penalty like suspension of pay for a month or 2 months, things like that. Those are the kinds of steps that could be taken to deal with problems that arise in the judiciary that might be considered indiscipline. As far as your mention of the book, Barrister Behind Bars, I remember I was a recently qualified barrister when I went to the Privy Council to watch a case in which a then Attorney General Ramesh Maharaj was presenting an argument. And I spoke to my dad about it, my late father. And he was kind enough to give me this, which is Ramesh's book. And I will tell you this, that any aspiring lawyer or those who want to know why there is such a controversy about removing the Privy Council, which is what this seminar is about, should read that book. Because I've read it over 10 times and it has reaffirmed my belief that Trinidad and Tobago at this point in time is not ready. I hope that's of assistance.
Thank you, Mr. Biharilal. I know we have a question from the media.
Good day to the panel. Darren Baho from the Newsday. Mr. Maharaj, Mr. Shara. I'd like to ask a question and may deem to be a little controversial. The major plank of the speakers today was the issue of trust and confidence in the judiciary. We have had in the not too distant past a yet unresolved allegations against a sitting Chief Justice. And then we have currently a very troubling issue about an Attorney General's ability to remember. These issues seem to touch on the average man in the street ability to have trust and confidence in the administration of justice and the judiciary. And you spoke about the Law Association being the voice. In the past, the Law Association has convened several special general meetings where a mere fraction of the membership would vote on motions of no confidence, which has not had the desired effect. So I'm asking, those issues that need to be resolved for the people to have trust and confidence, do you think that they need to be shored up? What can be done to educate the public to be more aggressive in terms of demanding accountability from these high office holders?
I'm sorry, I didn't get the first point you raised. The second point you raised is about the Attorney General. What's the first point?
The first point is the unresolved issues surrounding the Chief Justice, which went all the way to the Privy Council, and the Prime Minister took a decision not to invoke Section 137 of the Constitution.
Okay. Well, in respect of the second issue, let me deal with that first, if I can. With the Attorney General, I have taken the position because I have been contacted by the media as a former Attorney General, and I have taken the position that the matter is now before the Law Association, and they are going to have a special general meeting, and in deference to the Law Association and in deference being a former Attorney General, I would prefer not to comment on that issue at this time. In respect of the first issue, I think it is an important issue that affects the administration of justice, but I think that that is why I think that, the people the people ought to know all the facts. And normally the Law Association, if it is dissatisfied with what the Prime Minister did or what the Chief Justice did, it can go and inform the population about it. But in a democracy like this, where you have institutions which are given the power to take action, you also have the power to compel a body to take action, and when it is exhausted through the courts, there is nothing legally one can do about it. So I don't know if I have answered your question, but I think it's a matter of public opinion, and for the media and the Law Association and individuals to put pressure on those, public pressure, in order to see whether any situation can be redressed. But I want to agree with you, or I want to agree with what there is a problem in Trinidad and Tobago at the present time, in that I'm sure if you do a poll in Trinidad and Tobago about people trust and confidence in the administration of justice, they would give a lot of items that they would say that would have caused them to have lost some trust and confidence in the administration of justice. But I can tell you this, that notwithstanding the failings, there are failings, but notwithstanding the failings, there are very good judges in Trinidad and Tobago, and there are very good judges who uphold the traditions of the legal profession and they write judgments which can be comparable with any top country in the world. So there is a lot for the people of Trinidad and Tobago to feel confident in. We do not have a system that I can say 100% it's perfect, and probably no system is perfect. All systems of justice are infallible, are fallible, they are not infallible. So I think what we have to do, we have to take steps to strengthen our institutions. I think the legal profession has to be a little more vocal. I think the lawyers have to understand that the legal profession is just not to make money. It's not a commercial exercise. Lawyers must be prepared in certain circumstances to do pro bono work, to take up public interest litigation,
to put pressure upon the government, even it means to become involved in public legal education programs in order to get public opinion persuaded along a certain lines. And I'm sure you'll agree with me, the media plays a very important part in that role. And I think the media has been doing a very good job in Trinidad and Tobago.
Thank you, Mr. Maharaj. Any other questions from the media?
I just wanted to also say, in relation to the legal profession and the younger legal profession, I know that there are many young lawyers, some of them are actually here today, who I suppose have adopted the approach that Mr. Maharaj has taken throughout his life. I was one signatory with about 40 lawyers, and I was proud to be only one signature among 40 lawyers who decided to file a requisition to summon a special meeting of the Law Association. And of course, we hope that the numbers are not small. I know with virtual hearings, we have not yet had a response from the Law Association. I know that they are transitioning. A new executive, a new council has just been installed, so I know that they would work with dispatch on that. But insofar as it's my experience, there are a lot of young lawyers who are willing to take a stand, are willing to take matters pro bono. Some of them, our chambers, Mr. Rambally. I think what happens, and I think where it falls down, is that, and this is not of course, directed at Mr. Maharaj or Mr. Biharilal, who are very, very helpful to young lawyers, but there is a gap. I've seen it. In my experience, there is a gap between the lawyers who would take these types of matters and the younger generation. And filling the gap is sometimes, climbing a mountain. And I suppose that at some point, some group of lawyers have to, apart from the formal chamber system, which we more or less have, where lawyers join our chambers and they learn, we may have to get more direct with some of the lawyers for them to identify public law issues, identify issues which they can take up on behalf of the people, because you may see a complaint, but bringing a complaint to court is not enough. You have to have a cause of action. You have to have a complaint under the Constitution. You have to have a ground under judicial review. And therefore, sometimes it's a little difficult for young lawyers to find or to articulate it and draft it and plead it properly. And therefore, they become a little intimidated. But, there are lawyers who are willing. Many of them have come to me for assistance. And I know that, and I have confidence in the future of the legal profession that these matters will be addressed firmly.
Okay. Any further questions from the media? One question again.
Mr. Maharaj, I know that you may have been following the hearing of the Achille Charles matter in the Privy Council regarding bail for murder, which is under appeal by the state. The legislature as well as the police see the restriction of bail as a key weapon in the fight against crime. And in the circumstances of a local jurisdiction, local judiciary and so forth, the courts have been seemingly upholding that view in denying bail for people based on the legislation that is in place. In the event that the Privy Council rules against the state and strikes down the issue of bail for murder, giving the access for bail for murder, which is the capital offense in Trinidad and Tobago, do you see this as setting a precedent that could, in effect, apply to the Bail Act, which is now in place?
Well, in respect of murder, I have always taken the position, and when I was a young lawyer, I did a case, and you might have read about it. It's quoted in the Achille Charles case, a case of Sinanan. I got a dissenting judgment in the Court of Appeal from Justice of Appeal Sharma, or he was the Chief Justice, I can't remember. I took the position that the Supreme Court of Trinidad and Tobago has an inherent jurisdiction to grant bail in respect of any offense, because that is a function of the judiciary. And the executive arm of the state or the legislative arm of the state cannot take away that discretion, because that will be a breach of the separation of powers. What has happened from the Court of Appeal, it never went to the Privy Council because it was a case in the Court of Appeal, and I was asking for bail
pending the matter being heard in the Court of Appeal. I am of the view that the judiciary has to grant bail on certain guidelines and certain factors, and the executive arm and the legislative arm must be able to allow the judiciary to determine whether a person should be granted bail or not. I do not think that it is right for either the executive arm or the legislative arm to interfere with that discretion. Because if you look at the principles which apply for the granting of bail, there is almost every condition or every factor in which the court could impose a condition to ensure that the person does not abscond or that the person would face a trial. But it is not right. It is totally inhumane. It is cruel and unusual treatment and punishment to deny a man bail, have him on a murder charge for 10 or 15 years awaiting trial. No civilized society should be able to accept that. And I think that is wrong. And therefore, what has been happening in recent times, you have had this situation not being improved. You have had it being worsened. As a matter of fact, I know of cases in which persons were put on charges of murder. The evidence before the court was a case of manslaughter. The magistrate commits for murder. The man is in custody, and no action is taken to even charge a man for manslaughter and put him on bail. You cannot have an administration of justice that is respected and that people have confidence in if you take advantage and you oppress people. There's a presumption of innocence. However you may feel about an individual, he's presumed innocent until he is proven guilty. And what is happening in Trinidad and Tobago with some of these matters, they are proven guilty and they have to prove their innocence. I'm sorry to be emotional about this, but it is very wrong.
Right. We'll take one last question from the media, if any. That's it. I just want to, no disrespect meant to the panelists here in person, but I want to just give way to the furthest away, Mr. Biharilal QC, and we'll take his final comments, and then we close off. Mr. Biharilal?
Well, just responding to Aaron Baho's questions. First of all, to add with what Ramesh said in relation to bail. This comes back to the issue of assigning resources to the local criminal justice system. If you increase the number of judges, and increase the number of courts, and a decision is made to deny someone bail, that will not turn into 1 year, 2 years, 3 years, 4 years waiting for trial. If you have more judges and courts, you can try these cases within a very short period of time. So a person remanded in custody could be tried and convicted or tried and acquitted in a very short period of time and no more than 24 months. And it comes back to the question about the death penalty. Some criticism was made earlier about the Pratt and Morgan decision, that you cannot execute someone after 5 years. Well, the Caribbean Court of Justice has accepted that position and endorsed it. It cannot be right to keep someone in prison after you've sentenced them to death for 5 years, after they've already been in prison on remand full trial for 10 years. We need to have more resources where criticisms like that can't be made. And in the last capital case I did, my client considered himself fortunate because it was 6 years that he was in custody before I managed to secure his release. And I couldn't understand why he considered himself one of the lucky ones until I started looking about what the norm is. So all of these issues are directly relevant to whether we appeal to the Caribbean Court of Justice if we have a good enough justice system that affects our lives day to day in Trinidad and Tobago. And coming back to your first question, Mr. Bahor, in relation to the two issues you raised, well, as far as the unresolved issues in relation to the Chief Justice, I'm afraid the issue is unresolved. It may not be satisfactory, but that's where we are. In relation to the Attorney General, I understand why Ramesh, as a former Attorney General, does not want to comment on it. But I would say this. For those of us who are attorneys at law in Trinidad and Tobago, like myself, the Attorney General is the head of the bar. He sets an example. He sets the standard. And he should be a person who is not surrounded by this type of controversy. And I had high hopes that when he was appointed, he came with a clean slate. And I did not expect this controversy to arise. But until this controversy is resolved, he is not the right person to pilot any accession to the Caribbean Court of Justice. Whichever Attorney General does that must be able to do it without any baggage, to take the issues to the people objectively, fairly, in the way in which we are trying to do in this seminar. I hope that helps.
Thank you very much, Mr. Biharilal, for those profound statements. I know Shivani wanted to do a little introduction, but we'll bypass that. These Lakshmi Gill students said this is the longest exam they have had to write. It has gone past 3 hours now. Let me just say, give the vote of thanks on behalf of our Secretary General, Sri Vijay Maharaj, our President General, our Dharmacharya, the entire executive of the Mahasabha. We would like to thank all panelists. If I may say, Mr. Kyle Tacklalsingh, a very busy young man, and his introduction gave way to that. Ms. Karen Nunez Teixeira on very short notice, maybe about 3 days. Mr. Faris Al-Rawi was the person who would have represented the views of the government. Senior cabinet minister, he had a personal clash and he assured me on a future program he would present himself. But Ms. Nunez Teixeira was up to the task and therefore she consented to come in on the program. Mr. Biharilal QC, even today itself, it's about 4, maybe 5 hours still at this time that he is ahead. So even in his office at this time in London, we know that he is very much committed to assisting in a discussion, a very important debate in Trinidad and Tobago. So I would like to particularly thank Mr. Biharilal QC. I wanted to share some of our younger days as attorneys at law, but time wouldn't permit that, Anand, so I will bypass that today. Mr. Ramesh Maharaj, a person who really, he always gives of his time to the young lawyers and senior juniors as well. Daryl is here, he will testify to that. Kyle, myself, all of the lawyers, they will tell you Mr. Maharaj gives of his time. He's never too busy for imparting his wisdom for younger lawyers. He gives of his time for citizens who show up at his door. So if he doesn't have time, that is where he will call the younger lawyers and say, I need you to help this person, but he will not turn away anyone. That is the man, Mr. Ramesh Maharaj. And of course, the Mahasabha, he has been providing human service to the Mahasabha in terms of advice and you name it, the little things that turn up from time to time. So Mr. Maharaj, thank you very much. I just want to say on a lighter note with Mr. Maharaj, we have heard from Mr. Biharilal, Mr. Tacklalsingh, and Mr. Maharaj himself about barristers behind bars. I worked with his late wife for about a decade. She has a different story as to that behind the bars. So what she had to go through in support of Mr. Maharaj. But it is because of who he is, his tenacity, and he stands up for what he believes to be right. This is the quality that we need in all the citizenry at this point in time. Mr. Maharaj, thank you very much. Shivani, you did an excellent job, short notice, but very much up to the task. And I know she did a lot of research on her own, if in case she was inveigled into the debate herself. So I want to thank her. The pundits, attendees, specially invited guests. I see a lot of lawyers as well from different parts of the country, members of the media, viewers on Jagrati and our social media stream, YouTube and the Facebook pages, the SDMS Facebook page, to our technical team, Bimal, Vivek, Josh, Jason and Ricky. I know they had to promote this, a few days ago, and so I want to thank them. In conclusion, I want to let you all know that the Secretary General reminded me, in terms of, recall, Sir Dennis Byron was actually a close friend to the late Secretary General, Sri Satyanarayana Maharaj. And in fact, his view, and he shared that view, I was privy to one of those conversations. He was of the view that the CCJ needed to be more reflective of the society, and therefore he wanted to ensure that, you could see some Hindus applying for positions in that court, namely the judges of that court. So Dennis Byron, we recall those little incidents with him when he was there as the president of that court. He certainly reached out to us as an organization, and Mr. Maharaj, it will be down on records. Mahasabha Strike Back would have referred to these various conversations. Thank you, thank you, thank you. If we knew it would have been so long, we would have prepared lunch for everyone, okay? Thank you very much. We are now officially at an end.